Great. Thank you.
Okay, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. I'm Judge Milkey. With me are my colleagues, Judge Desmond and Judge Lemire, and we are your panel for the 5 cases we're hearing this morning. Our first case is Commonwealth versus O, 2021 P221. I want to remind the parties that we have read the briefs and the records. We are familiar with both the facts and the arguments. So I would urge both sides, to the extent possible, to cut to the chase. So with that, I will turn the floor over to Attorney Yannetti.
Thank you very much, Your Honor. Good morning. My name is David Yannetti. I represent the appellant in this case, James O. Mr. O was convicted after what was essentially a one-day trial in Superior Court, resulting in a sentence of 12 to 15 years. Mr. O was prejudiced, not only by the admission of inadmissible hearsay to devastating effect. He was also prejudiced by his attorney's failure to properly prepare his defense by using a forensic psychiatrist to explain issues to the jury that were beyond the knowledge of a layperson, and these errors justify a new trial. Your Honors, I have limited time today, I recognize that, so I'm hoping to fully argue the inadmissible hearsay argument while relying on my brief for the most part on the issue of defense counsel's failure to obtain an expert, recognizing that the court may have questions about that of course I'd be eager to answer.
Yeah, I have a pressing question on that issue,
sure.
if I may. The judge focused on the issue that defense counsel did not violate, if you will, the first prong of Safarian, because he was not on notice that a repressed memory issue was present in this case. There was nothing in discovery or grand jury minutes, et cetera, that flagged that issue. How do you respond to that?
Well, I guess I would respond to that by saying, Your Honor, in her decision, the trial judge, who was also the motion judge, allowed and acknowledged that because the accuracy and reliability of the alleged victim's memory of past events was the central issue at trial, it's likely that a forensic expert's testimony, as we proposed it, about the general characteristics of memory formation, including how it may be affected by trauma, et cetera, would have been admissible.
No, but so, counsel, I hear you. And I hear the argument that once the trial was in progress, there are all sorts of flags that came up about these issues. My question is, what put counsel on notice that these could come up before the trial? It's fairly typical, as I'm sure you're aware in these cases, that there's a long period between the alleged events and the reporting of the sexual assaults. So there's nothing unusual about that per se. So what in discovery or otherwise put counsel on notice that repressed memory issues, that issues of dreams and flashbacks and that sort of thing would come up?
Sure, and I apologize for not answering the court's question directly. With regard to the state of discovery pre-trial, Your Honor, I would argue that there are 2 factors that should have alerted counsel that he needed the help of a forensic expert. One was the delay in reporting, and despite the fact that this is a common occurrence in these types of cases, analogizing it to eyewitness cases where there's also a common sort of fact pattern, and the SJC has written on the fact that forensic experts are necessary and helpful in those cases. I would argue that they're helpful in these cases as well, but buttressing that is the fact that prior to trial, defense counsel was on notice that a dream or nightmare was the trigger for these allegations. He alerted the court to that during the hearings on the motions in limine. And so, he knew that that was going to be an avenue of attack, and really one of the few avenues of attack that he had on the alleged victim's credibility, because he had no theory as to why she would make up these allegations. He did not know he had nothing to indicate a motive to lie. So his only defense here was either that she was lying or that she was mistaken. He couldn't argue that she was lying because he had nothing. And he admitted that he had nothing, essentially, to the jury when he said, you don't have to even answer that question. So he had to go on the theory that the alleged victim was mistaken. He was on notice that a dream triggered these allegations, and he was completely ill-equipped to cross-examine her about that because it was outside his area of expertise, and he really did nothing with it.
Did a dream actually trigger the allegation? I thought she dreamed it, and she lied to her boyfriend. And then a few weeks later, she made the allegation. So
Correct.
Whatever happened a few weeks later, or why she waited a few weeks, I mean, it happened a few weeks later. So what prompted her a few weeks later to say I was lying? I don't know, had anything, what was the triggering was the dream. So I'm not sure that the dream triggered. She did say that she had these flashbacks as a result of becoming a little bit more sexually active, and that these things were a little more familiar to her. So I'm not convinced. Convince me that it was the dream that triggered the allegation.
Thank you, Your Honor. So with regard to the flashbacks, those came up after the evidence had started and trial had begun. So focusing first on what was known prior to trial, what was known prior to trial is that there was this dream that that she had said was affected her greatly.
Right. She killed herself.
I'm sorry?
She said, I'm familiar with the dream. She said that she had this dream. She was very upset. She told her boyfriend that she had killed herself, but that really wasn't the truth.
Correct. And then to answer the court's question, when she did ultimately report it, she referenced the dream in the text message that later became the first complaint evidence in this case. And she said, when I told you about that dream, I was lying about killing myself. What it was really about was the abuse that I'm now claiming. So that's my basis for claiming that, or for pointing out that I believe that was the trigger.
Do we know why she changed her mind and decided to tell the boyfriend 3 weeks later? What was?
I don't know that the record was clear on that, other than that she was continually affected by that dream. And it would have been helpful for defense counsel to get help from a forensic expert regarding the interplay between dreams and reality, and how one can intrude on the other. He had nothing to explore that because he was uneducated about it, and he sought no help. So, I'm happy to continue talking about the second issue now that we're on it. I would switch back to the first if the court would allow me.
I just want to
Sure.
ask a related question, and that is, and keeping in mind you're talking at least here to an old civil practitioner, what opportunities of discovery or what have you were available for counsel to learn more about the memory related issues pre-trial? Were there avenues that could have been explored to be more prepared on these issues?
I think so, yes, Your Honor, because in the pretrial discovery, there was mention of the alleged victim being taken to treatment post-dream in this case. And, I suppose had defense counsel been focused on this aspect of the case, perhaps there would have been some basis to bring a motion pursuant to Commonwealth versus Dwyer, or to try to get those records in some fashion. But even without those records, the fact that we're talking about a dream as a trigger, I think should have sent warning bells off to defense counsel that this would be an area to explore, especially in a case like this, where he really did nothing with her on cross-examination. I would argue really he at most shored up the Commonwealth's case by allowing her to explain the dream in flashbacks in a manner that was harmful to the client.
Okay, counsel, I want to give you an opportunity to get to the issue you wanted to highlight.
I very much appreciate that, Your Honor. And I don't mean to be rude in any fashion. I would like to get this part of the argument out if I can. So with regard to the apology and to a lesser extent, the request not to report it, I think the apology is the prime error in this trial. I think it has to be stated that the apology by the wife was perhaps the most important piece of evidence that came in. In a case like this one, where the alleged victim tells one story and the defendant tells the opposite, any third-party witness who pushes the evidence in one direction or another is important, but a defense witness who pushes the evidence in the direction of the Commonwealth is paramount. And that's what we ended up having here. I don't think the judge intended that. And certainly defense counsel tried to prevent that, but that's what we have. The real danger of admitting the wife's apology was that it easily could have been seen, and I would argue probably was seen, as a confession by the defendant. Because the chronology here is that the wife testified she learned of the allegations, she went back and talked to the defendant, and then returned to the victim's mother and apologized. The fact that it's the wife who is apologizing naturally had to cause the jury to speculate about what the wife knew or didn't know from her conversation with her husband, and whether she secretly got the information from her husband that he actually did it.
But
so there was a real danger. And I would argue it's almost inevitable the jury would attribute the apology to the defendant.
Doesn't she say, after she speaks to the husband, that he denied it?
Well, you know what? Yes, she does. The problem is the judge disallowed the defense counsel from introducing that in evidence. So the jury never heard the denial. They were left to completely speculate about what the husband had told her. And the reasonable inference is that he confessed to it because she then apologizes. That was the danger. And the trial judge was aware of that danger. She specifically prohibited the Commonwealth from suggesting that the wife was apologizing for her husband's behavior. She admitted it on two grounds, one being credibility, the other being bias. Neither ground is valid in this case, Your Honors. Regarding credibility, here's where the rubber meets the road. The apology is only admissible if it's inconsistent with her trial testimony. And the court should note, the Commonwealth argues on appeal something different than they argued before the trial judge to get this evidence in. On appeal, the Commonwealth argues in its brief on page 26 that the apology was, quote, inconsistent with the wife's position at trial that her husband was falsely accused. There are two things wrong with that argument. First, the wife never testified that her husband was falsely accused. And secondly, the Commonwealth is now suggesting that the apology means that the wife knew her husband was guilty, yet at trial, the Commonwealth was prohibited by the judge from introducing the apology to suggest that she was apologizing for her husband's behavior. Now, at trial, the Commonwealth's argument was that they were trying to impeach the wife's denial that she had ever walked in on a sex act. That was the only ground that the judge allowed with regard to credibility, that statement to come in. But the judge quickly recognized the danger of admitting it, and the judge did not do a voir dire, which would have avoided what happened at trial. What happened at trial is the Commonwealth asked the question in a way that caused the judge concern. The parties went to sidebar, and the judge stated to the prosecutor, it's in the record, my concern is the way you phrased the question. Quote, did you ever apologize to her about what happened? The jury may infer that you're suggesting in the question that the witness was apologizing for her husband's behavior, and that's not the reason why I said I'd allow you to go there. So the DA, after being admonished, goes back, elicits the same apology from the witness, but then asks the open-ended question, why? That open-ended question led to the precise testimony that the judge had barred. Quote, because I was told the victim was molested. There is case law, Judge, that is cited in I think both briefs, especially the Garcia case cited by the Commonwealth. It was also mentioned during trial. Admitting a pseudo confession in this way is unduly prejudicial. My argument is the objection was preserved. The judge said it was preserved, so you only have to deal with prejudicial error. However, under any standard, this created a substantial risk of a miscarriage of justice because of the powerfulness of what could be seen as a confession by my client. I have a lot more to say, but I see my time is up.
Well, let's see if either of my colleagues has a follow-up question.
Not so much a follow-up question, but earlier in your argument, you said that it was your position or your observation that you didn't feel like the trial counsel really were able to do much with the complaining victim. But didn't he kind of go at her credibility pretty good? I mean, he put in pictures of the house to show how kind of small the house was and the proximity of things as to where she said this was taking place. He attacked her credibility with relatives, saying that they had no memory of, either waking up and being told to go back to sleep or walking in while this incident was taking place. And he led with, do you even kind of believe it? Did you start with, I had a dream and you're not sure that this happened or something like that? I mean, wasn't all that before the jury?
With the paucity of evidence that he had, he tried to do something with it. The problem is any ordinary fallible lawyer who tries these cases would have recognized the necessity for an expert. And the elephant in the room was an apology that came into evidence, which was inadmissible and highly prejudicial, far outweighing any probative value that it would have had.
Got it.
Okay, thank you very much. We will hear from the Commonwealth.
Good morning, Catherine Jansen on behalf of the Commonwealth. I would also just like to acknowledge that the victim and her family are watching via the live stream. I would just like to start out with that. This is a case where it's just the victim's statement against the defendant's statement. I think the defendant actually did have a lot to work with here, including 3 defense witnesses who directly contradicted or really undermined the victim's testimony regarding some of the nature of these allegations. And so that was strong evidence under which the defendant was able to attack her credibility. And as far as that second issue, I would suggest there was nothing to put the defense attorney on notice that this was that repressed memories or cover memories or inaccurate memories were going to be an issue. In the first complaint text messages, which are part of my impounded record appendix, it is clear that the dream was not the trigger per se of these allegations. She goes on to tell her boyfriend that she always thinks about this. She's been thinking about this, that this is not something that just came up because she believed it. And, to the extent that she used the word flashbacks in her testimony to describe the fact that these are recurring memories that stay with her and that she didn't want to believe it, the defense attorney seized upon that issue. And I would say really ran with that in his closing.
But isn't there, in terms of potential impact on the jury, a huge difference between a lawyer trying to make hay of it through cross-examination and an actual expert talking about the science and the potential inaccuracy of repressed recollection or memories?
Well, I would suggest here, first of all, because there was no evidence, I would say either in pretrial discovery or from the trial testimony that these in fact were repressed or recovered memories, that an expert on that wouldn't necessarily be relevant or admissible because there has to be some link between the evidence and that testimony. to the extent that there could have been expert testimony regarding memories in general and the general formation of memories, which I would suggest if we're going to require it in this case, we're going to have to require it in almost every case because witnesses are always testifying about memories and memories can be inaccurate. That
No, but counsel, it's wouldn't you acknowledge it's somewhat unusual for a witness to be talking about flashbacks, and more particularly the testimony that because of her becoming more sexually active, she suddenly had the feeling, wait, this is familiar. Where do I know this from? That strikes me as more unusual than the average case.
I wouldn't characterize the testimony as the fact that she's saying, well, this is becoming more familiar. Why is this happening? I think it's kind of just bringing the fact that this happened more to the forefront of her mind. I don't think it means she forgot it. She said she never forgot it. In fact, you know, if the defense attorney had consulted with an expert, I don't think it would have helped the cross-examination of her because she very clearly said, no, I've always remembered this. I think flashbacks just happened to be the term in which she used. I don't think it was meant to say, I all of a sudden I had this flashback and it just came back to me. But to the extent, even if this court were to find that, you know, that created a basis in the evidence, which I would not concede that it did, I would suggest here, even based on Dr. Tittman's affidavit and the factors he discusses in his paragraph 11, I don't suggest that this testimony would add much, the expert testimony would add much to fighting the victim's account. I mean, he talks about whether it's been consistent. She's always been consistent from the police reports to her first complaint to her trial testimony. The specific nature of when it started, what type of the graphic details of the abuse, where it occurred, when it ended, how it ended.
So on that point, I thought the doctor in his affidavit said that you know, she didn't really talk about specifics, that they were more general, and that was a concern for him with respect to reality or not. But didn't she speak to specifics? Didn't she talk about the specific incident in the bedroom when the aunt actually walked in? And didn't she talk about the specific incident when the cousins woke up, though they didn't remember it, and the father told them, you know, I'm just tucking her in or go back to sleep or whatever he said?
Absolutely. I think you hit the nail on the head. I don't think there was a basis in the testimony for that claim in his affidavit. I think, you know, these are pretty specific. This was ongoing abuse, and those are pretty specific graphic details about specific instances and exactly what had occurred. I'm not totally sure what more the victim could have said besides, you know, the defendant was wearing jeans and a red shirt that day. I mean, so I think based on that, I mean, there wasn't a basis in the evidence for that. And I think that would have been really damaging to his credibility via cross-examination from the prosecutor. And as far as the studies about trauma, clearly being sexually abused is traumatic, but a lot of the studies which he is citing are eyewitness studies, and often, you know, eyewitness events and studies are from a singular event where, you know, it's weapon focused or other issues like that. I would say that's very different from ongoing sexual abuse from somebody that you're very close to. So to the extent that this testimony would have been admissible, I think it would have been of marginal relevance. And I think at the end of the day, there was fruitful evidence that the defendant could use and did use to try and undermine her credibility regarding the nature of these allegations.
Yeah.
So, go ahead, Jim.
Now, I was just going to say hypothetically that the traffic light that these issues could be of relevance at the trial didn't really come until the trial itself. What were defense counsel's options at that point? Obviously, counsel tried to do the best job that he or she could, but are there circumstances where one could ask for a delay in the trial? Hard to think, you know, on a trial so short you could do that. I mean, I'm trying to say, if it became obvious at that point that repressed memory issues were of concern, what could be done? You
know, I think the answer is, quite frankly, not much can be done. I don't think a mistrial would have been granted. There would be no reason for it, I think. And I think a continuance, a judge would not have abused their discretion in denying a request for a continuance once this came to light, especially because I don't think it really came to light based on the nature of this testimony.
I would think at best there would have been a voir dire on that issue to maybe meet out some of the particulars as to whether it was a repressed memory or just a memory she was finally voicing that she had all the time, which is, I believe, what the prosecution is suggesting. And that came out during the cross-examination and the direct examination. So there's probably little, if anything, other than a voir dire that would have been done at that point, I would think.
I correct. And I think, right, the voir dire, we kind of know what would come out from the voir dire, as you said, Justice Lemire, that, this wasn't a repressed or recovered memory. So I don't really think there's much, defense attorney could have done should the red light have, or light have gone on.
I'd like to just shift. Go ahead. I'm sorry.
No, I was going to do exactly what you were doing, so go ahead.
I'd like to just shift gears for a moment and ask you to address some of the forceful arguments that your opposition raised with respect to, isn't it a little misleading to let the jury know that he apologizes without informing the jury that in that same conversation, he's denying that he did anything? And to get the apology before the jury, but not the denial, why is that not a problem?
I don't think that's a fair characterization of how the evidence came out, that it effectively suggested that she talked to him and he denied it, or that he admitted to it. I think my memory of the testimony and how this all came out was that they had a meeting. There was evidence that, after she found out the allegations that she was molested, the prosecutor then asked, did you apologize? She didn't say, did you go home and talk to your husband and then apologize? That's not what happened. That's not how the testimony came out. And I think to the extent that, versus rehabilitating on redirect examination, or even what evidence that suggests, why did she apologize? It was out there that at the time she apologized, she knew nothing from any source, from the family or from the defendant, beyond the fact that there was this allegation that he molested. There was nothing to suggest that she knew that part of the allegation was that she had walked in, and that she was just saying, I apologize because, I'm sorry that we're in the, essentially that we're in this situation, I think is how it could be taken. And I think that there's a basis in the evidence for the defense attorney to argue that should he have wanted to, and for the jury to find that. And I do think that this apology was relevant to one, as a prior inconsistent statement, because it tended to be different from her trial testimony, and also as bias, which are the two reasons why the judge allowed this in. It goes to bias because it's completely different posture, an apology about this upon learning of these allegations, a completely different posture than her posture at trial, which is, I never walked in, and essentially, inferentially, although she never said the victim is falsely accusing the defendant, that's the import of her testimony. So it definitely goes to bias in that respect. And I do think it's inconsistent because it was for the jury to find the jury any ambiguity in the apology, which I think there's a basis in the evidence based on the victim's claim that she walked in and saw this, that she could find, I'm sorry, I knew this happened, or the jury could say, I'm sorry that we're in this situation. And that was for the jury to sort out. I don't think.
Counsel, I may be just being stupid, but how does the apology show her bias? The bias is kind of obvious in that she's married to the defendant. How does the fact that she was offering an apology show much of anything other than she may have knowledge that he did it?
Well, I think just because the bias is obvious because she's married to the defendant isn't necessarily the only way the Commonwealth is allowed to impeach somebody with bias, even if that is part of it. Commonwealth is entitled to put on its case in full. And if there's other evidence that would suggest bias, and I would suggest this does show bias because it's different than, I think bias and the inconsistency are very interwoven. It's a kind of interwoven argument, but it shows bias in that her testimony is biased in favor of the defendant because it's different than her tenor before trial, which was, I'm sorry, and not saying this never happened, or I never walked in. So I think that it tends to show that her testimony isn't to be believed. And I think,
I
I'm
thought
sorry.
I'm sorry to interrupt you. Go ahead. Let me let you finish that answer. I apologize.
yeah, I'm thinking I was maybe going in circles. So go ahead.
I thought I read in her grand jury testimony that she said, we repeatedly tried to talk to them about it. Yes, we had the family meeting. The husband, I don't think, was there. I went home and I spoke to him, and we repeatedly tried to speak to him. We went by the house. She wouldn't let him in. She wouldn't talk to him about it. And so I thought if I said I was sorry, she might let us in to talk about it. Did any of that come out?
It didn't, but the defendant wasn't precluded from bringing that out. When you look at the sidebar discussion, which is volume 2, pages 156 to 162, you know, the defense attorney made an offer of proof about what to say, and part of that wasn't part of it, but also because he wanted to get in the defendant's denial, and also that after she read the police report and she was alleged to have walked in, that that's when there was no doubt in her mind. And the judge said, I'm not going to allow you to bring in anything about, there's no doubt in my mind about the allegations, because that's a comment on credibility, and I'm not going to allow you to get in a self-serving denial. But to the extent about why she's apologizing and what she thought it would do, such as be able to talk to the family or get in their good graces or whatever, that was not precluded in the judge's ruling. So, you know, just because that didn't come out, I don't think that makes the judge's ruling and finding that.
Okay, but if the testimony that did come out about the apology implies that they may have had a conversation about the merits of the allegations, why, under the doctrine of completeness, shouldn't the fact that the defendant denied the allegations come out?
Because I don't think, based on the wife's testimony, there's any suggestion that she had a conversation with the defendant. The question is, did you learn about these allegations? And, you know, she said yes.
So what was she apologizing for?
So she said, well, the prosecutor said, did you ever apologize or make an apology? She said, yes, I did. And so she said, and then when she was given a chance to explain it on cross and on redirect, she said, you know, I was just sorry that this happened. And I think that there was a basis in the evidence for the jury to say that, like, she either believed the victim's allegations at that point, or she knew what happened. I mean, there was no suggestion that she had a conversation with the defendant about this. And I don't think that's a fair reading of the evidence. And I don't think that would make it misleading.
Well, there was also an allegation that she had walked in on one of the acts, and it seemed to stop after that event. So that then when it comes out, I mean, it might have been natural for her to say she was sorry at that point based on those facts. But I mean, so there were various reasons why she could say she was sorry. The fact that it ever happened, the fact that she never disclosed it, the fact that her niece was a victim of an abuse, just generally. I mean, there were various reasons.
Correct. And I think, right, there was a basis in the evidence for that apology based on the victim's testimony and allegation. And, you know, the jury could decide what that apology was for. And there was basis in the evidence for the defense attorney to argue it as much as he should. He kind of stayed away from it. And that was a tactical decision, which is not, you know, challenged on appeal. But, you know, it wasn't just that, oh, I talked to my husband and he said it happened. I mean, there was a basis in the victim's testimony. And I would
But it doesn't go to the truth of the matter that the husband did something. It just impeaches her credibility about things that were said about what she had seen, and then her denials.
Absolutely. That's exactly right. And that's why the prosecutor offered it. And that's why the judge admitted it for that purpose.
And the overriding case law is you don't let a general denial into evidence.
Correct.
By a defendant.
Correct.
Right.
I'm happy to answer any further questions. If not, I'm happy to rest on my brief.
Aren't there rule of completeness exceptions to that general rule?
There are, but I don't think those are implicated in this case, because this case isn't about, you know, the apology is not just about whether or not, like, she talked to the defendant. I don't think that's because this isn't hearsay for that purpose. So I don't think that this like touches upon verbal completeness. And that wasn't argued to the judge below either.
Wasn't it kind of implicit? If she's going to talk about the apology, then
No, and I think she was given an opportunity to talk about the apology and why she apologized. So, you know, I don't think this is where, you know, the defendant's completely foreclosed from doing anything about this.
And the defendant testified.
Correct. And he denied it.
And she wasn't apologizing for him.
Correct. And if you look at the motion in limine, a lot of this discussion about the voir dire and all this other stuff, because the text message had said, right, like, you know, he wants to apologize the most. And, you know, the judge was like, well, that could be hearsay. So we need to know if that actually came from the defendant or if it was, you know, the victim's mother putting words into his mouth, because it's her family and she wants to be close with them. And, you know, this is going to destroy their family. So, and it was clear. And the judge said, I'm not going to allow that in about that, because that would be like saying the defendant acknowledging that this happened. That would be improper hearsay if it's not his words. But, you know, this was clearly based on what this wife wanted to do with her family. And I think that was fully vetted. And the prosecutor was, the defense attorney was allowed to fully air that, whether or not he misunderstood some of the judge's rulings at sidebar and didn't fully go to the full extent that he could have, you know, that might be the case, but I don't think there was error in admitting this apology or, you know, the judge's rulings on this.
okay. Do either of my colleagues have any follow-up questions?
If he did the latter, doesn't that support your brother's contention that he had ineffective assistance?
Well, the claim of ineffective assistance was based on the memory issue. So I don't think that if you're doing ineffective assistance straight on the trial record, I don't think there's really a basis on this record for ineffective assistance based on this, especially where, you know, at the end of the day, you know, my brother says, if you have one defense witness, when it's a credibility case tending for the prosecution, that is just, it's prejudicial error then. I mean, here, she was a good defense witness in the fact that she said it never happened to street denial, piling on top of his, but also his two sons who basically said, the stuff in the living room never happened. I have no memory of it. So, you know, at the end of the day, if you were going to look at ineffective assistance of counsel based on this specific issue, which was no.
Counsel, I think we understand the argument.
I got it. I will say, I apologize referring to your adversary as your brother. He's your adversary in this instance. Sorry about that.
Well, thank you very much.
Very interesting case. Thank you.
Okay, we are live and recording.
Thank you very much. We are back on the record in our second case of the morning, Commonwealth versus RIVADENEIRA. My apologies if I mispronounced that. 2021 P290. I want to remind the parties that we have read the briefs and the record, so we're familiar with the facts and the legal arguments. So I would urge both sides, to the extent possible, to cut to the chase. And this is a Commonwealth appeal, so we will hear first from ADA Williams.
Thank you. Good morning, Your Honors. May it please the court. Whitney Williams, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. Commonwealth would ask this court to reverse the allowance of the defendant's motion to suppress and find that there was reasonable suspicion to stop Mr. RIVADENEIRA at the time of the stop. Primary error in the motion judge's reasoning was to laser focus on one particular factor, which was the description of the suspect, rather than consider the totality of the circumstances as the case law suggests. Particularly, a couple of factors the court ignored altogether were the public safety element, the fact that there was a report of an armed suspect with a firearm, as well as the nature of the circumstances of the stop itself, particularly the proximity to the crime, both in time and distance, and the nature of the path on which the defendant was walking when Officer Ramos stopped him. Considering first the public safety element, Officer Ramos was responding to an emergency tone of a report of a home invasion that had just occurred with both suspects fleeing and carrying firearms. Officer Ramos knew the area, and when he heard the direction of travel, he headed to a dirt path, which was beyond a chain link fence behind the direction where the suspects had fled. And if you look at Exhibit 1, that is the map of the area, it's very clear that this path is separated from the residential area. And as Officer Ramos testified, it's separated by a chain link fence. Officer Ramos entered the path at the only place that a vehicle could enter or exit the path. And that was some blocks away from Corbett Street. As he drove down the path, he saw no other individuals. And then at the very end of the path, stepping onto railroad tracks, he saw the defendant, Mr. Rivadeneira. He fit the description of one of the two suspects, that being a man in a blue hooded sweatshirt. When he saw the defendant wearing the hooded sweatshirt, he attempted to get him to turn around simply by asking him to stop. And when the defendant did not turn around, that's when he ordered the defendant to stop and initiate the stop. And the question posed by this is, in these circumstances, what do courts expect an officer to do? He attempted to initiate contact by getting him to turn around, and only at the point when the defendant ignored him and continued walking, that's when Officer Ramos ordered the defendant to stop.
Counsel, can I just drill down on one fact?
Yes.
Because I'm a little unclear what the Commonwealth's position is. As you know, the police report mentions a hood on the other person's jacket, but not on the defendant's. At the hearing, I believe the officer testified that it was hooded. What are we supposed to make of this in terms of what the judge found? Is it clear that the judge accepted the hearing testimony that it was hooded? Because the absence of the police report is obviously, some evidence that it wasn't, and the judge wasn't required to credit the officer's testimony. So what finding must we accept or not here?
So the only testimony with respect to the actual description was that it was a hooded sweatshirt. On cross-examination, the officer was impeached with the fact that his report only mentioned a sweatshirt. Specifically, the report said a black man in a black hoodie and a Hispanic man in a navy blue sweatshirt is what the report said. His testimony was that it was a black man in a black hoodie and a Hispanic man in a blue hoodie. When asked about this on cross, he acknowledged the discrepancy in his report, but never adopted his report statement.
I understand that.
Yes.
But the judge did not have to accept his testimony that it was hooded. So what exactly did the judge find, or did the judge skirt the issue?
My recollection of the judge's findings of fact were that she did adopt blue hooded sweatshirt did find a blue hooded sweatshirt to be the fact that she found. But I would argue that at the end of the day, the description was of a sweatshirt, and it was a blue sweatshirt. And whether the defendant's sweatshirt had a hood or didn't have a hood, it still matched the description of a blue sweatshirt or a blue hooded sweatshirt. There was no testimony, and it's not in the report, that the description was of a man wearing a crew neck sweatshirt or any sweatshirt that didn't have a hood, just that it was a navy blue sweatshirt. So either way, the clothing description fit, whether or not the broadcast that the officer heard specified a hood or not.
But the more specific the description is, the more it helps the Commonwealth's case, I assume.
I agree, and I would argue that the testimony was clear that Officer Ramos recalled hearing a description of a hooded sweatshirt.
So he's observed. First of all, this is 9 o'clock in the morning.
Yes.
So this is broad daylight, 9
Yes.
o'clock in the morning. He's observed walking by himself. He's not with any co-defendant, and he's walking with seems to be a fairly traversed dirt path. So, no?
I would argue that that's not what the testimony showed as far as well traversed. The testimony was that this was a dirt path that essentially led to nowhere. It's pretty clear on the map that The only point of entry is, as Officer Ramos described, without jumping the chain link fence, is blocks away down onto a public way. That's where he entered with his cruiser. The path doesn't lead to anything. It leads
I thought it led to this train track area.
Yes.
And one of the concerns that the officer had was that he was going to go over this bridge, and
Yes.
then it would be a while before he'd be able to get around to him, and he might lose him. I thought that was a concern that the officer had.
Absolutely. And my point about the tracks not leading anywhere is that the tracks don't lead anywhere that it would be logical for a person to go. They only lead to the train tracks, which is somewhere which would be dangerous. And as I pointed out in my brief, illegal for the defendant to walk along. And the railroad bridge certainly would not be a safe manner for anybody to travel across the river. At the end of the day, the place where the defendant was located is not a place that would be logical for him to be, particularly walking onto the railroad tracks, unless he was the person who was fleeing the scene of the home invasion that had just occurred.
To what extent, if at all, are you making an exigent circumstances argument?
I wouldn't characterize it as an exigent circumstances argument so much as a public safety concern that should be a factor to be considered within reasonable suspicion. So the courts are very clear. They have not carved out a public safety exception to the reasonable suspicion rule, but they have been very clear and consistent that particularly the report of an emergency situation with a firearm does factor in and should be considered when determining reasonable suspicion for the stop. And courts have described a balancing test that an officer should consider, balancing the risk that an innocent person would be stopped versus the risk of a armed suspect fleeing and getting away. And here we have a report of an armed suspect entering the train tracks in the description of a railroad bridge. Officer Ramos would have no way to pursue in his cruiser. He would have to initiate a pursuit on foot, which I would point out would be a more significant stop than the minimal intrusion that he did do by ordering the defendant to stop and turn around.
There was some discussion at the motion hearing, but it's not really raised in the briefs as to when the incident occurred as compared to when the dispatch of the incident. In other words, is there anything that infers that the home invasion was broken up by the sheriff's deputy and the process of it, and therefore the dispatch was his seeing of the defendant was within minutes of the event, or just within minutes of the dispatch?
So the testimony was that the emergency tone, the priority tone, one tone, is only used in emergency situations where someone actively has a weapon of some kind and is fleeing a scene. He described that as being an indicator that this is an incident that just occurred. The dispatch was that this is an incident that just occurred. The fact that the circumstances involved a sheriff who broke up the home invasion, those were facts that weren't learned until after this dispatch went out, because the dispatch went out immediately as the 911 call was coming in. So information was being gathered at the scene by some officers at the very same time that Officer Ramos was going down this path. And his description was that he arrived at the end of the path just 2 minutes after this dispatch went out. So given that it was a priority one tone emergency situation, given that this was a response to a 911 call, the information that Officer Ramos had at the time that he performed the stop was that this was an incident that had just occurred minutes prior.
Did the motion judge rely primarily on the Warren case?
The judge did weigh the Warren case very heavily in her decision. And Warren is very distinguishable from this case. In Warren, the suspect was stopped a mile away from the crime 25 minutes afterward. So if you consider kind of a radius that expands over time, if you consider the speed at which a person could get away on foot, the radius just expands the longer that we get from the crime. And that radius represents the area in which a defendant could be found. In this case, that circle is very, very small. We have about 2 minutes after the dispatch, maybe 5 minutes since the crime occurred, if we're assuming there's some sort of delay before 911 is called. A person can only get so far on foot at that point. So we're considering a much smaller area. And then we also have a direction of travel that was relayed to the officer, and he went in that direction of travel. So that circle is actually almost cut in half when you consider that direction of travel. And within that very small area, Officer Ramos sees someone walking onto railroad tracks.
We got it.
Where
We know.
matching the description. I would also just note that that Warren does involve someone who was just walking down a residential street, not doing anything suspicious. Whereas in this case, we have this person in an area makes no sense for him to be walking onto some railroad tracks.
He wasn't doing anything suspicious, right? He was just walking down a dirt path.
Arguably, he was committing the crime of trespassing onto railroad tracks.
Can I,
Even before he reached the railroad tracks, he hadn't quite reached them or was about to reach them, whatever. When he was first observed, he's walking down a dirt path.
Yes, but
So what's suspicious about that at 9 o'clock in the morning?
it is not in itself a reason to stop somebody. I agree. I don't think that any one of these factors by itself is reason to stop somebody. But the fact that the person is walking away from the location of the crime onto railroad tracks where there's nowhere to go other than onto railroad tracks is certainly suspicious.
I mean,
Well,
he's not the
let me-
first person to walk along railroad tracks. Let me ask you this question. The fact that he doesn't stop, and I know you say it's very distinguishable from Warren, I think they also cite cheat. When the officer first tries to get his attention, my words, and he doesn't acknowledge the officer, can we consider that? Is that part of the reasonable suspicion factor?
Yes, I wouldn't argue that it's a significant factor, but it is a factor. I mean, certainly the case law acknowledges that people have the right to ignore the police if they want to ignore the police. But the fact that this person wouldn't so much as turn around and acknowledge the officer is evasive conduct in a way. And the courts have been very clear that evasive conduct is a factor to consider. I would argue that it's not the most heavily weighed factor in this case. Certainly the proximity to the crime and the nature of the area, as well as the report of a gun, are much more significant factors. But it is yet another factor that Officer Ramos
Let me just probe that a little bit. If you have a right not to talk to the police, but when you don't talk to them, we're going to consider evasive, then what kind of right is that?
I agree. And if someone's walking down the street, minding their own business, and an officer for no reason yells out, "Hey, I want to talk to you," and they continue walking and the officer has nothing else to go on, absolutely, there's no reason to stop that person. But here, Officer Ramos was already interested enough in this person based on the factors that I've already outlined, that he attempted to initiate contact for those reasons. And this is exactly the behavior that the defendant in the defendant's brief suggests that Officer Ramos should have done, which is some lesser form of initiating contact. And that's what Officer Ramos was attempting to do. The question at that point is Officer Ramos then required, simply because the defendant didn't turn around, to allow him to continue onto the railroad tracks, cross that bridge, and walk away, with Officer Ramos having no choice but to watch him walk away.
Well, didn't he have the option of calling a brother officer and saying, "Hey, he's about to get on the railroad tracks, meet him on the other side of the bridge"? I mean, once you're on the railroad bridge, you either go to the other side or not, right?
Yes, but I would note that the report was of a person carrying a firearm, and a bridge is a perfectly logical place to go to dispose of a firearm. And that certainly should have been a concern of Officer Ramos's at that point.
counsel, on the trespass argument, had the Commonwealth prevailed on the motion, it presumably could have raised the trespass argument as an alternative grounds for affirming. The Commonwealth lost the motion. What allows the Commonwealth to raise an argument before us that it never raised in the trial court?
The issue was raised in the Commonwealth's motion to reconsider the original ruling. So that was raised.
Isn't that too late?
So the case that I cited, Commonwealth v. Rodriguez, where an issue is raised within the time afforded for appeal in the lower court by means of a motion to reconsider, the court can consider that on an appeal. I acknowledge that it was raised only at the point of the motion to reconsider, but the Commonwealth's position is that the fact that the defendant was trespassing on railroad tracks was even further reason to consider stopping him, further reason to find his behavior suspicious, and reason to reverse the allowance of the motion to suppress.
Do either of my colleagues have any follow-up questions? Seeing none, thank you both for action. Sorry, we'll hear, used to the Commonwealth arguing last. We'll hear from the defendant, Attorney DeVore.
Good morning. May it please the court. My name is Attorney Melissa DeVore, and I represent WILLMANN RIVADENEIRA. I know that you've read my brief and the Commonwealth's brief and the reply brief, so I will cut to the chase. I want to first address something that's been raised both for the first time in this oral argument and in the Commonwealth's reply brief, which is the time of the stop. So on page 16, lines 15 and 16 of the transcript, that very first encounter of the officer with my client, he got on the PA system and ordered my client through the PA system of his marked cruiser to stop. He didn't get out and ask to speak with him. The initial encounter was an order to stop. I'd suggest that when you apply the Mendenhall test, a reasonable person would not feel free to leave when an officer commands them from their PA system to stop. And that's distinguishable and has been distinguishable in the courts for a long time from commands to stop have been distinguished as a stop in the constitutional sense from just requests to stop. So I'd suggest that the stop did occur at this initial time, as the judge found, when the officer commanded my client to stop. Next, I just want to touch on.
Let me just ask you right then, where do you say your client was at that particular moment?
That particular moment, I believe the testimony was he was reaching the railroad steps, the railroad tracks. And that would be the first time, and that he was
he on the tracks, or was he on the dirt path?
I believe he was on the dirt path, just about to get onto the tracks at that point. The next point I'd like to raise is the Commonwealth's distinction from this case. They're saying it's more akin to the Acevedo case. Well, the description in the Acevedo case was of white Converse sneakers, and I felt like it was difficult to convey in a written brief, but these, just so the court can see, are white Converse sneakers. The kids call them, they're kicks Chuck Taylors, Chucks, thank you. They're a unique style of sneaker. These are very different from what you might picture as your generic sneaker. They're a specific brand and a specific style, and that was the description in the Acevedo case. So it can be difficult to convey in a written brief, but these Converse sneakers are very unique, and that's what makes it different from this case, where all we have is the description of a navy blue sweatshirt without any further detail about a logo, a brand, a style. And so I do think that that's an important point that this court should consider when determining if the Acevedo case or the Warren case is more applicable. The other point I want to address is the Commonwealth's position that this was an isolated trail. I suggest that that's simply inaccurate from the testimony. If you look at the transcript, on page 33 of the transcript, the officer concedes that this is a pathway where people can run and walk their dogs. We know from the map that this is a pathway that's behind a condo association and a residential area. And so this is certainly a pathway where people can be walking, and it's not abnormal for someone to be walking at 9:30 in the morning. Like I said, the officer said in his testimony on page 33 of the transcript that this is a place where people can walk and run and walk their dogs. So there's no reason to suggest that this was a path going nowhere. I think, as Justice Desmond had suggested, to walk along train tracks is certainly not uncommon. And I think in numerous movies that people have seen, you see people walking along railroad tracks. It's not an uncommon thing for someone to be walking along a path where you can walk your dog or run. And at 9:30 in the morning on an October day. And that's distinguishable from some of the other cases that the Commonwealth cited in their brief. Because, for example, in the McCoy case, I believe it was, yes, the McCoy case, in that case, the weather was horrible. It was peculiar to see somebody walking outside in horrible weather, just kind of deciding to take a walk on that day and time. But that's not the situation here.
But we apply it, don't we apply it to the entirety of the circumstances, the proximity to the crime, the time of the crime, the matching description of the blue sweatshirt, and kind of tie that up with the fact that it was an armed home invasion, that there was a weapon involved? I mean, doesn't that all come into play, other than somebody's out for a walk on a day that the police officer had no reason to stop?
I do think that you have to put everything in context. And I think one of the things that the Commonwealth tried to do was they often would talk generally about the scene of the crime and the proximity to the crime. However, in this case, there was actually 3 separate areas that are mentioned. So the location of the crime was on Corbett Street. And it's a bit confusing because all these things sound the same, but there was Corbett Street was where the crime occurred. The dispatch said the suspects were headed towards Cabot Crossing. So that's another area that's depicted on the map that was entered into evidence. And then my client is found in this pathway behind all that. And I think that unlike all the other cases that were mentioned by the Commonwealth, there's no evidence that of any officers about the area of Corbett Street or Cabot Crossing, because the only officer who testified never went to those areas. So we have no idea how many people were walking around Corbett Street and Cabot Crossing at 9:30 in the morning.
We have some idea, however, about the distance between where your client was first observed and Cabot Street, where the crime was occurred, right?
Yes, and I don't.
And that was clearly within a reasonable length for him to have walked from that Cabot Street point to where he was first observed in the couple of minutes of the dispatch.
Yes, and I think if the officer, I think one of the things the officer could have done was simply gotten out of his cruiser and said, "Sir, can I talk to you?" And I'd suggest that that's what he should have done, instead of going immediately before he even knew if my client matched the description, the racial description provided. All he knows at this point is that there's a person in a blue sweatshirt in front of him, and he immediately jumps to a constitutional stop, which we all know is legally significant. And so
can I ask you a question about the time of the stop? It's my understanding that he initially made a broadcast over his PA system to stop. And when the defendant looked back and then continued to walk, he exited his cruiser and then, I don't know, then told him to stop again. It's my understanding the judge found the stop to be the second demand and not the PA demand, which was more like, "Hey, I'd like to talk to you," but he used the word stop. But the judge did not find that was the point of the stop, if I read her findings correctly. Do you agree?
So I know what you're talking about, but if you read the actual decision, the decision says that she found that the stop occurred before my client turned around and the officer was able to see him. And so if you put that finding of fact that she basically incorporates into her rulings of law. So in her rulings of law, she says that at the time of the stop, the officer had not yet observed my client's face. And that would make it after the initial command to stop. And I'd suggest that that's consistent with the case law out there. That she even cites that a command to stop would be a stop in the constitutional sense. So I do think it was a small oversight on her part that she said the stop occurred when he stepped out of his car. I think maybe she had confused the testimony and thought that he had not yet turned around or something to that effect. But certainly I'd suggest that the stop happened at the moment that the officer goes on his PA system and commands my client to stop. And there's no basis that the Commonwealth has been able to articulate as to why that wouldn't be a stop in the constitutional sense.
Well, I mean, that's not what the judge says, though.
What she says in her rulings is, and I believe it's page 6 of her decision, that the officer had not yet seen the defendant's face and could not tell his race or ethnicity at the time of the stop.
So why can't both of those things be true? How far from him was the officer when he first engaged him, whether it was by the PA system or not? I mean, somebody can turn around and still be a significant distance from you and you still can't make out their ethnicity.
I suppose I agree with you, Your Honor, but the fact that she said he couldn't see his face led me to believe and the fact that she said, the fact that she had said he had not yet seen his face is what led me to believe that he had not yet turned around. Which I think is
perhaps it was because he had the blue hood on.
Perhaps, and if she made that finding, Your Honor, I don't think that that's consistent with the case law.
Well, putting aside the nuance of whether the officer should have gotten out of the car and approached him as opposed to using the PA system, what was the officer, in your view, supposed to do? Assume that your client would not have stopped and cooperated and would have kept walking. Could the officer at some point order him to stop, or must the officer, having arrived on the scene of a recent armed home invasion in close proximity in the immediate aftermath at the location that the officer appears to have surmised someone might try to escape, what are they supposed to do? Let the person walk away?
Well, what the judge had suggested at the motion to reconsider, and what I would suggest, is that the officer needs to first ask if he can speak with this person. It's a simple, sir, can I speak with you? Because at this point, from an officer's perspective, he just sees someone walking down a path. That's enough to inquire, sir, can I speak with you? And I would yell that out a couple of times. I think the officer has the opportunity to either try to drive the car further or himself try to give pursuit of this man. Like he could get out of his car and run and run after him. And again,
couldn't the running after him be considered a stop?
No, that actually has been found. So long as he's not yelling at my client to stop, the case law has held that that is not a stop in the constitutional sense until he's, until the chase kind of gives way a little bit longer. Is my client running away? I think there has to be additional factors that then turn what is a kind of threshold inquiry into a stop in the constitutional sense. And so at some point, yes, it might become a stop in the constitutional sense if my client were to have continued to run away. But those are all, first of all, not facts in this case. And second of all, that changes the situation. And the courts have held that the suspect, if someone's running away and ignoring a police officer's request to speak with you, that those then become factors in the analysis. And so now we have more going on here, if that's what's happening. Now we have a blue sweatshirt and somebody running away from you. And perhaps at that point, he would have been able to see his face. So I think all of those things factor in. One of the also other points I wanted to make, and I made it in the argument as basically a footnote in my brief and also before the judge at the argument, but that is, I think it's questionable to take as a finding of fact that the officer at the time of the stop knew that the person he was chasing was a male. If he hadn't, at the initial stop, he sees a person in a navy blue sweatshirt, and the officer testified that he could tell it was a male just from seeing him from behind. And I would suggest that you can probably make a pretty good assumption if someone doesn't have long hair, maybe by their gait or their posture, if it's a man or a woman, but you can't tell for sure when you see someone from behind if it's a man or a woman. And so I think at that point, now all we have is a person in a navy blue sweatshirt at the time of the stop. And I think that that makes it even less. And again, at this point, they're not fleeing, they're not running. I think the officer should have simply investigated more, asked him, sir, can I talk to you? sir, can I have a moment of your time? And that's what we want police officers to do, to start that engaging with what could be a completely innocent civilian, basically on the right foot. We don't want it to start off as an adversarial, get on the PA system, command to stop for somebody who's simply walking down a path in a navy blue sweatshirt.
Okay, Counsel, before we conclude, I'd like you to address the same issue about the hood on the blue sweatshirt that I asked the ADA. What did the judge specifically find? And what is open to us under Jones-Pennell?
I do think that the judge found that it was not a significant finding, a significant fact that changed the analysis of the case. It was her opinion that whether or not it was hooded or not hooded, it was still a very vague description.
No, I understand that, but it was certainly open to the judge to make a finding whether she credited the officer's testimony that he knew it was a hooded sweatshirt. And it doesn't appear that the judge made a definitive finding on that. Would you agree with that?
Yes, I would agree with that.
Okay, do either of my colleagues have any follow-up questions? So now we finally have reached the conclusion of the case. Our thanks to
We are live and recording.
thank you very much. We are back on the record in our third case of the morning, 2020 P 1422. This is John Doe number 526596 versus the Sex Offender Registry Board. I would remind the parties that the case is impounded, so please no reference to the names of the respondent or obviously any victims. With that, I will turn the floor. Oh, actually, before I do that, just want to remind the parties that we have read the briefs. We're familiar with the facts and the arguments, so we would urge you both to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Hernandez.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant in this matter, John Doe. As you know, the Sex Offender Registry Board classified my client as a level 2 sex offender. I'm here today to request that this court either lower my client's classification level from a level 2 to a level 1 or remand the case back to the board. The board's decision was arbitrary and capricious and an abuse of discretion where the hearing examiner incorrectly applied regulatory factor 38, which is the one dealing with victim impact statement. And according to that factor, the hearing examiner is required to take into account any statement authored by the victim. In this case, the victim did author a statement and submitted it to the board. And within that statement, the victim indicated that he believed my client should not be required to register, that if he is required to register, that he only be required to register as a level 1. And also she indicated that he poses no threat to the community or to children, and that she felt safe in regards to Doe.
So
With all that,
can't the examiner consider that and then reject it?
absolutely, but if you read the decision, it doesn't even look like the examiner even considered it. The examiner only chose to concentrate on one small portion of the statement, which indicated that he received mental guidance for the abuse that he suffered. And so that's all he quotes from within that statement. And the statement's about, I think it's 2 pages or a page and a little bit over a page. And again, there's many other things within that statement. So there's no indication that the hearing examiner actually looked at the entire statement, just basically focused on one small portion of the statement.
Okay, but as a follow-up question, of what either relevance or materiality is it that this victim doesn't think your client should have to register as a level 2. The registration presumably has little to do with protecting her from your client to the extent such protection is appropriate. So, I mean, how is it even relevant whether or not she feels he should be a level 2, a level 3, or a level 1?
I mean, I agree that the victim cannot dictate to the board which level to classify anyone. But in this case, the victim does know my client very well, and she indicated that she felt that he didn't pose a threat to anybody in the community or to children. So I think that is something very important that the hearing examiner should have taken into consideration. And there's no indication that he did take that into consideration.
But there is, I mean, tell me if I'm wrong, but I don't believe there's anything in the record that even suggests that your client poses a danger to children. This was all an adult sex offense. So
he does state he does impose a danger to the community in general. He does add specifically children in there as well, but he does indicate that he didn't believe that he posed a danger. The exact words were, let's see, it's on page 169 of the record. I think it's on this, I'm sorry, let's see.
But suffices to say, she's not the expert.
No, she's not, but she does know him, and she has known him for many, many years. And in her opinion, he does impose a danger. He's put threat to the community. Those are her words. But he does impose a threat to the community. So I think that's something the hearing examiner should have taken into consideration. There's no indication from reading the decision that he did take that into consideration.
Can we infer that she didn't think he was a threat to her either when she went over there?
I'm not sure if you could infer that. I mean, many years had passed from the time that he did this act and the time of the classification hearing. So a couple of years had passed, and at this point, about 5 years has passed. So people do change, and it's a possibility that she felt from what she's seen that he was no longer violent. In addition to that, and no longer a threat to sexually assault anybody. Again, the hearing examiner, as required by Factor 38, should have taken the totality of the statement into consideration when writing the decision, and there's no indication that he did so. So because of that, I would say that it was error for the hearing examiner to fail to take the totality of the statement into consideration in this case. And actually, there was a second argument that I had regarding Factor 7. And I've never done this before, but I'm going to do it today. I'm going to withdraw that argument because I did have a chance, and that was regarding Factor 7, which is the difference between extrafamilial and intrafamilial. I do agree with the board, which is rare, but I do agree with the board that previous counsel should have brought it up at the Superior Court in terms of arguing that this factor, the definition of intrafamiliar, should be a little bit different, but he didn't argue that, at the Superior Court, and I don't think I have the right or the legal authority to argue it here. So just to save the court's time, I will withdraw that as an argument. And I would also assert that the board failed to prove by clear and convincing evidence that my client poses a moderate degree of reoffending. As you know, my client is in his late 30s. He only has one index crime on his record, and it was against somebody he knew who he shared a daughter with. He was going to be on probation after he was released from incarceration, and he has the strong support of many family members and friends. You'll see in the record there's many letters of support submitted. One was from his stepfather who raised them. Another one was from his mother, his present fiance, multiple friends, and his brother. They all indicate that they are familiar with the sex offense that he committed, and they are choosing to support him. Nonetheless, many of them supporting him financially and with rides and making sure he, lives a good life moving forward.
So the hearing examiner considered the letters but wasn't the defendant also had a restraining order against him by this particular victim, had engaged in a previous domestic violence incident with a different victim, was on parole at the time of this incident?
That is all correct. And I would assert it is fair to look at all of that in terms of his history and what his risk to reoffend is moving forward. Again, even with all of that, I would assert that he poses a low risk of reoffending. Again, it was one victim, one index crime, somebody he knew, he shared a romantic relationship with and had a child with. So under these circumstances, absolutely, he should register. I'm not saying he shouldn't, but I believe he poses a low risk of reoffending based on all of this. And I would also assert that because of these reasons as well, that his information should not be publicized, even if he continues to be classified as a level 2, because the victim—
Counsel, to what extent are you, on this point,
Yes.
are you arguing insufficiency of the evidence supporting internet publication? And to what extent are you arguing that the board, at a minimum, did not adequately explain the reasoning, where it just sort of has a general statement, well, the public could benefit from this?
Yeah, I would say that I'm arguing both, but I'm more so arguing that there's really no, what is the language? So it has to be realistically served to protect the public from him reoffending. And here is a very specific, very small pool of victims that he could possibly reoffend if you look at the history, which is somebody he was in a romantic relationship with, who he had a child with, and obviously knew really well. So that would not necessarily protect any public, unless, again, is somebody he's in a romantic relationship with, and you would assume they probably already know about any past sexual assault or abuse prevention orders issued against him.
I think you lost me on that. Why would we assume that?
Oh, yes. I mean, when you're in a relationship with somebody, you tend to know a little bit about their history. His fiance that he's in a relationship with today knows about his history. So him being placed on the internet would not necessarily protect her, because she already knows about his past and all that. But in terms of protecting the public at large, there's really not a pool of, besides a very specific pool of victims that he could potentially offend against. And again, that's somebody he knows is in a romantic relationship with, and in this case, actually had a child with. So for these reasons, I would assert that his information should not be publicized on the internet.
So the pool is all possible future girlfriends?
That's what I would assert, because if you look at the past, that's the only person he offended against.
And you think that that's a small pool?
I think that's a very small pool in terms of internet dissemination. Yes, I do.
And I assume part of your point is he's engaged, and therefore we can't assume there'll be any future girlfriends.
That's what I would assume at this point, because I mean, if you were to place him on the internet or not, that his fiance already knows about his prior history. He submitted a letter of support to the board, so she does know that he was convicted of sexually assaulting a previous girlfriend. And
so do we know how long that relationship with the previous girlfriend was?
At least it began in 2011, at least from the record. It could have began before that, but I know she was pregnant in 2011. It could have begun in 2010, but at least 2011. So for multiple years, 6 years or so before.
But my recollection is we don't know how long they may have lived together, if at all, from this record.
Yeah, there's not. I reread the record a couple of times because I know some information that's not in the record. Unfortunately, it never made it to the record. But I reread the record a few times, and there's no indication at all how long they've lived together, even honestly, if they even lived together at all. And there's no indication they were married either, so that's not in there either. But I know in 2011 she was pregnant, was having his daughter. So they at least knew each other beginning 2011. It could have been sometime before that, but it's not a great record, to be honest.
And the police report from the prior incident with a different woman, is that in the record, and where?
Yeah, so that was, let's see. That was March 4th. That was after this relationship. So that was March 4th, 2018. And this incident happened August 12th, 2017. So that was somebody, I don't know if he was involved with her or not, but that was somebody. I mean, it looks like they were because they were living together. That was
And that's
somebody.
in the record. The police report itself was in the record?
I believe so. I think it's on page 96.
Thank you.
It's on page 96. Yes, it's in the record. And if there's no further questions, I'll rest on my brief.
Seeing none, thank you very much. We will hear from the board and Attorney Michaud.
Good morning. May it please the court, Attorney Rachel Machad for the board. Since Mr. Doe has withdrawn his argument regarding factor 7, he takes issue with only the application of one factor in this case, and that's additional factor 38, which is the victim impact statement. The victim in this case authored a statement discussing the substantial impact that the offense had on her. She said that she hoped that he wouldn't have to register because she was concerned about the well-being of her daughter. She did not explicitly opine that he's not dangerous. And in fact, on the last page of her letter, she specifically says that she has other orders in place to protect herself. Regardless, the hearing examiner's analysis and task here is one of public safety. So where the victim was clearly concerned for her daughter's well-being, the hearing examiner's inquiry is really towards the public. I included a 128 decision from 2012 in my brief, and that's Doe 161-119. I will note that that's under the prior regulation, so it does discuss the victim impact statement, although I believe then it was factor 23. And really the only difference between the regulation then and the regulation now is that now it's a little bit more inclusive as to who qualifies as a guardian. But the holding of the panel of this court in that case was that where the hearing examiner's role is to consider public safety, he may strike or disregard portions deemed speculative or conclusory as to the ultimate issue of dangerousness, which I suggest is exactly what happened here. The prologue of the additional factor 38, the victim impact statement, is that the board recognizes the substantial impact that the offense has on the victims and will consider the victim impact statement. And that's exactly what the hearing examiner did here. He considered the victim impact statement and the substantial impact the offense had on her in assessing dangerousness. And we know—
But counsel, is this a one-way ratchet, or could the board have considered the victim impact statement as the respondent prefers? And before you answer that, let me just say, in the analogous criminal sentencing context, you sometimes have victims come in and say, you know, this was a horrible thing that happened, but here's why I forgive the person and don't fear the person and think he should not have to go to jail. And tell me if I'm wrong, I think a judge is free to consider that.
I think in a criminal context, you know, it is in part punitive, whereas here it's more a concern of protection of public safety. So here, I guess looking at what we usually get for victim impact statements, I will say that we often get victim impact statements that impress upon us which level the victim thinks appropriate. Often it's in the other direction. And I think that either way, it's completely improper. The victim obviously has their own subjective views on it. They don't have the guidance of the factors. They don't have the expertise that's imbued in the hearing examiner by the board. And so it would just be wholly improper to consider it for anything beyond what the regulation permits, which is recognizing the substantial impact that it has had on the victim.
When you read the victim's statement, I mean, she never comes out and says she's no longer in fear of him. She says, I think she says she has a restraining order in place. She's had mental counseling for over a year. It seems like she's more concerned about the impact of the stigma of being labeled a sex offender online, that it may impact on her daughter or her child. But I mean, I didn't see anything in there that says she's no longer in fear of him.
Correct. I would agree with that. In fact, as I said, the last sentence, I believe, of her victim impact statement is discussing that she has other orders in place to protect her.
So it's the significance, according to the examiner, is the impact it had on her, which seems to be, as I think the examiner said, significant.
Right. And if you look at how that factored into the discussion portion of his decision, it's considered only in terms of dangerousness. And as we know from 496501 in the relevant case law, dangerousness is defined by the case law as the extent or severity of harm that will befall a victim in the event of reoffense. And I suggest that considering the substantial impacts that it had on her is exactly in line with assessing dangerousness. So there was no error there. And in terms of substantial evidence, that's the only factor that the offender takes issue with. There are many risk elevating factors present in this matter. And
we turn to the issue of internet publication. Tell me if I'm wrong, under existing law now, the board has to, by clear and convincing evidence, find that internet publication is warranted in this case. Do you, in this context, accept as established by this record that he is engaged to be married?
So he was, at the time of hearing, he was engaged to be married. I don't know if that victim is the same victim of his 2018 domestic violence incident. That occurred after the sexual assault against the victim. He was with this other woman. I'm not sure if that's the same woman or not.
But you're speculating at this point.
Well, wasn't he married to the woman in 2018, the victim in 2018? Wasn't that his wife?
I haven't seen any evidence that he was actually married. I don't know if that's just a statement that he was making to the police. And it is in the record appendix 96. I know that the reporter said it was a couple that lived in the building, and I know that he referred to her as his wife. I don't know what their actual marital status was, or I haven't seen anything that corroborates that in the record. But either way,
he referred to the victim as his wife.
Correct. That is correct.
So
but that was, again,
help us understand what purpose internet publication would serve and how there is clear and convincing evidence that it is warranted in this case.
Sure. So he committed a sexual offense against an extrafamilial victim. That's no longer an issue in this case. It's accepted at this point. She was, in fact, extrafamilial. It was a contact offense. The offender in 496.
Can I just stop you there? It's extrafamilial under the definition that is in the regs. It doesn't change the fact that she was the mother of his child. So
correct, but at the time that he sexually offended against her, they weren't living together. They were no longer in a relationship.
Okay, but
really
focus on internet publication. What purpose would this serve? Who is the population it's trying to reach? And is this perhaps a blunt tool to try to reach that publication where any member of the public could go online and find out this person is a level 2 sex offender because of a single incident involving the mother of his child?
So he committed a contact offense against the victim, which is greatly different than the facts of 496501, where it was an offender who was exposing himself across the street from the victim. He committed this sex offense against a woman who he was not in a relationship with. The public safety interest here is satisfied by informing adult women in the community in his geographical presence, which I believe is included in the quotation cited by the hearing examiner in his decision, to take appropriate safety precautions. So it would enable them to know about his presence and risk. And I will note that there is some confusion in the record regarding his relationship status now, as he sexually assaulted this victim in August of 2017. And then there was the domestic violence incident in, I believe it was May of 2018, against the woman that he referred to as his wife. And then later, the person who submitted a letter of support as his fiance in September of 2019. So I don't think that this is a limited pool. If you were to have his information online and disseminate it online, it would allow any woman who is similarly situated to the victim, who again, I know that Doe characterizes her just as the mother of his children, but she was more than that. She was a woman who was at one time in a relationship with him, and then was just, I guess, known. She knew who he was after that based on the relationship that she had continuing because of the child. But internet publication would enable all women in the public to take appropriate safety precautions, being aware of his geographical location and risk.
What is in the record with regard to substance abuse issues? My recollection is that in the indexed offense, the victim said that he appeared to be under the influence. What do we know about this?
Correct. He was under the influence at the time of the offense, and the police report, I believe, also notes a heavy alcohol odor when speaking with him. He also was convicted of OUI in August of 2017, and he was intoxicated during several domestic violence incidents throughout the record.
And is there anything in the hearing examiner's ruling that addresses whether or not he has any of these issues under control?
Let me just check on that, Your Honor. I'm sorry. I don't believe that there was any evidence presented that he had undergone any counseling or had those issues under control, and none were noted in the hearing examiner's decision. Factor 9 is stressed on the decision, page 13.
In the March 2018 incident where he refers to the victim as his wife, wasn't he arrested for OUI in that incident as well?
I believe that he was under the influence. I'm not sure that he was arrested as a result of it. But I believe he was observed to be under the influence. Correct. And if no questions, I'm prepared to rest.
He was charged with OUI, right? That's what it says in the police report.
Yes, Your Honor.
Do either of my colleagues have any follow-up questions? Seeing none, I think I heard you conceding the rest of your time. Thank you both very much.
Okay, we are live and recording.
Thank you very much. We are back on the record in the fourth case of the morning, ATHRU Group Holdings LLC versus SHYFT Analytics Inc., 2021 P560. I would remind the parties that we have read the briefs and we're familiar with both the facts and the arguments, and therefore, especially in a case this complicated, we would urge counsel to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Milkey.
Thank you, Your Honor. My name is Joan Milkey, along with my colleagues, Mark Cahill and Kevin Quigley. I am privileged to represent the plaintiff appellant. Phonetically, it is ATHRU Group Holdings. In Gaelic, the actual name is ATHRU Holdings. As this court knows, the case comes before the court for de novo review of the allowance below of a motion to dismiss a verified complaint. The context of this case and every decision that this court is being called upon to make turns on who knew what when in 2017, when the first of the two subject transactions occurred. I therefore ask that when defendant's counsel rises, the court recall that any deficiencies in the pleadings regarding specific facts as opposed to circumstantial evidence supporting inferences are a product of the fact that the defendants have now resisted discovery in two contexts. Of course, by moving to dismiss successfully. There was no discovery in this case, but even before that, with regard to the first of the transactions, a stock purchase agreement by which minority shareholder ATHRU, the founding shareholder of this closely held corporation, SHYFT Analytics, had exercised its rights under the stock purchase agreement to request the books and records to review the transaction by which Metadata Solutions acquired SHYFT. That request was denied multiple times, forcing ATHRU to do its own investigation to come up with the circumstantial evidence that you have seen, that in 2017, SHYFT CEO, Mr. King, recruited Stephen Hirschfeld, the retiring COO and the vice chair of Metadata, to the SHYFT board. In the summer of 2017, all information about Metadata ceased to be shared with the board, at least when ATHRU's representative, John Corcoran, was present. In August of 2017, Metadata suddenly had a person participating in the directors' meetings of SHYFT, even at the invitation of Mr. King, even though as a minority shareholder, Metadata had no right to participate in the directors' meetings. In late August or early September of 2017, senior executives of SHYFT visited senior executives of Metadata in New York and concealed that meeting from Mr. Corcoran, their co-director and the principal of ATHRU. Against that backdrop, when the subsequent acquisition after ATHRU had sold its shares back to other shareholders of SHYFT, when Mr. Corcoran on behalf of ATHRU called for the records and books, they were denied. Hence, we come before you without the factual evidence that would allow explicit factual representations about the status of the Metadata acquisition as of the time of the stock purchase from ATHRU.
Can I just ask you, did they conceal the meeting or did they just fail to disclose it?
Well, the allegation in the verified complaint, which we must go with, of course, Justice Desmond, is that the meeting occurred, and I believe the language is that it was concealed from SHYFT or from ATHRU, from ATHRU through Mr. Corcoran, the director. That is, he is a director, and he is a director who didn't know. It would appear the other directors did know. So the information was not provided to the director who is the principal of ATHRU. And ATHRU at the time was offering its shares because it had a third-party purchaser for those shares, but the other shareholders in SHYFT had a right of first refusal. So we are in a context where the key issues that you would be asked to look at substantively are knowledge, intent, and materiality. You've all been on the bench a very long time, and you know that all three of those items are fact-specific and require context, which ATHRU has been deprived of receiving. And I would point out that while the principal claim in this case is for breach of fiduciary duty, 2 of the first 3 counts in the verified complaint relate to the refusal of SHYFT and Metadata, who succeeded to the obligations of SHYFT, to allow the review of the books and records concerning that acquisition. Now, a corporate defendant doesn't simply ignore its contractual obligations. It has to have a reason. And even this fact that they just refused to allow the review is suggestive that there was something there they did not want ATHRU to learn. Therefore,
Counsel, let me just return to maybe the 20,000 foot level. Your clients had a stock purchase agreement that expressly addressed the possibility that the stock could be resold for much higher sums. And your clients, as part of that, signed some sort of acknowledgement that, and I'm paraphrasing here, but that they had the information they needed Why doesn't all this, what you consider suspicious circumstantial evidence, have to be viewed against that backdrop? And of course, the rules that fraud must be pled with specificity.
Well, the stock purchase agreement is the document that ATHRU is contending what it was fraudulently induced to sign. I mean, we'll go back to the basic principle. You can't have a release from an uninformed releasor. And this goes beyond that because we're talking about a situation with fiduciaries failing to disclose information to their minority shareholder. So the stock purchase agreement is itself at issue here. He was misled by omission into signing that agreement because they did not disclose, the two fiduciaries, the two other directors, what they were legally obligated to disclose. He can't be held to a release or waiver that was premised on their fraudulent omission to disclose to him that they weren't actually talking about the future.
Counsel, how about the acknowledgement of what I characterize as we have the information we need?
Well, of course, you can't know what you don't have. This is, again, a non-disclosure case. Remember, non-disclosure cases under Delaware law, which governs the breach of fiduciary duty claim here, trigger something called the special facts doctrine in just these circumstances. A minority shareholder in a closely held corporation where two insider fiduciaries are in possession of information that a transaction involving their company is under discussion, and they know that the minority shareholder isn't aware of that. So they allow the minority shareholder, who obliviously goes forward, believing that there is nothing happening with the company of which it is the founding shareholder, and certainly expecting that the other two directors are going to tell their director about this going on. And so, in reliance on the highest duty of trust imposed by law, the fiduciary duty, where they were obligated under the special facts doctrine to tell the minority shareholder, they didn't do so. So nothing that's in that stock purchase agreement can be used against ATHRU because ATHRU was misled by a fiduciary omission into believing that it was business as usual when it was anything but. So not only is it a future provision, whereas the transition at issue was actively going on, it is a circumstance where two fiduciaries were obligated to tell their shareholder and about the transaction, and it is all the more troubling when you've got the founding shareholder, who obviously has, as is pled, owns all of the preferred seed stock with the special privileges that are set forth in the voting rights agreement, attaches Exhibit C to the complaint at section 3.5, ATHRU, all by itself, could block this transaction with metadata.
ATHRU approached them for the sale to begin with, right? He wasn't approached.
That's correct, but that's what the this doctrine is all about. Frankly, the special facts doctrine is the circumstance where the minority shareholder approaches the board, and the fiduciaries at that point have to tell the minority shareholder. That's what this doctrine relates to. It doesn't relate to them coming to him. That would not be a non-disclosure case, respectfully, Your Honor. This is a non-disclosure case. Non-disclosure doesn't always give rise to liability. So in Delaware, going back many, many years now, the Chancery courts developed the special facts doctrine to address a circumstance where fiduciaries are approached by a minority shareholder. The fiduciaries know that they have a transaction underway. They have discussions going on.
Well, let me stop you right there. They have discussions going on. Doesn't there have to be some level of seriousness of those discussions before they have to disclose it? In other words, we've had some meetings. There's been some talk about us merging. There's been some buyout discussions, but we haven't really reached the level of any kind of talk of numbers or anything like that. Where does that line, when is it drawn? At the inception of, hey, we got a call, we're going to have a meeting, or we've had 10 meetings and we're about to draft an agreement?
Well, Your Honor,
somewhere in between.
Well, it isn't drawn on the kind of timeline you're talking about, because the Chancery Court recognized a couple of decades ago that the minority shareholder isn't going to have the information as to what the stage of the process was. Here, they should have had it because they had a contractual right to get it, but couldn't. But normally your minority shareholder says, oh, wait a minute, I just sold you my stock and then you're selling the company. So instead, they replaced what in the 1980s, the rule was the price and structure rule. And that's the one defendants misled the judge below into following. Back in the 1980s, what at least one Delaware court had said is for it to be actionable when a fiduciary failed to disclose in these circumstances, the discussions had to have reached at least a decision as to price and structure. In 1988, I believe it was, the United States Supreme Court on the federal side rejected that bright line and said that doesn't make any sense. So somewhere along the line, no later than 2004, which is still 13 years before this transaction, the Chancery Court in the Alessi case said, forget about price and structure, forget about trying to find a place on the timeline, because the plaintiff isn't going to know that, the minority shareholder. So there are going to be two tests. First was the undisclosed fact material, which was defined as a substantial likelihood that a reasonable shareholder would think it was important. And second, was the undisclosed fact one that would actually affect the value of the company, make it more valuable? And in this case, the pleadings are very clear on that point, and there is nothing but the verified complaint here. Remember, that's essentially an affidavit in front of the court. It's a verified complaint that stood unrebutted, in which ATHRU says, we absolutely would not have sold our stock if we had been told that Metadata, who at the time had been a minority shareholder for about a year in SHYFT, was interested in acquiring us. Now, SHYFT is a small, closely held company. Metadata is a much larger publicly traded company. And ATHRU quite reasonably said, we wouldn't have sold if we knew that was under discussion. We could have waited. And then on the second fact, did it materially affect the value of SHYFT, that Metadata was going to acquire it, which it did do, it did acquire it. Yes, it did. All you have to do is look at the prices, even with the minority factor taken out of it, the minority shareholder piece. You've got 75 cents a share paid to ATHRU, and then several months later, after the transaction was finally completed, you've got in excess of $2.95 per share, $195 million paid by Metadata to SHYFT. So both of those tests apply. And please, Your Honor, I'm glad you raised the question because it used to be the law that it was a timeline where you had to have a certain level of process in place. That was changed, not for an ultimate change. I mean, ultimately, it's still going to matter, but at the motion to dismiss stage, clearly plaintiffs didn't have the ability to say where they were in the timeline. So one must go into discovery, and in discovery and after discovery, which is where the cases cited by defendants typically reside, then a presentation can be made as to whether it was known to the fiduciaries and intended by them not to be known to the minority shareholders. I see my time is already up. That went quickly. Are there other questions?
At base level, Judge Salinger determined that the special facts doctrine didn't apply as to King because he didn't buy the shares directly from, how do you pronounce it, ATHRU?
ATHRU.
So what do you say to that?
That's not the law. The law is that the fiduciary has to either be the purchaser or be the facilitator of the purchase. King had a lot to gain in this transaction. You'll see that in paragraphs 57 and 8 of the complaint. He was the facilitator of the purchase, and that's all that's required. That's under Wayport, Shell Petroleum, and Arnold. There's a long line of cases on that. So that one, the judge, by the way, came up with on his own. That was a sua sponte ground. That wasn't raised by the defendants. And with all due respect to Judge Salinger, who is a fine judge, it was wrong as a matter of law. It's Delaware law. It's not law he's dealing with on a daily basis. Thank you all very much.
Do either of my colleagues have any further questions? Seeing none, I will turn the floor over to Attorney Martin.
All right, thank you, Your Honors. Kevin Martin on behalf of the defendant appellees. Your Honors, plaintiff argued below that it was fraud and a breach of fiduciary duty for defendants not to disclose mere expressions of interest in a SHYFT metadata merger. The Superior Court correctly dismissed those claims with prejudice, and it also correctly dismissed plaintiff's breach of contract claim because it needed to go to arbitration. I'd like to focus on 3 points today, Your Honors. First, plaintiff waived any argument about undisclosed negotiations by specifically arguing below that its claims were not based on negotiations, but only expressions of interest. Second, non-disclosure of mere expressions of interest cannot support a fiduciary duty claim as a matter of Delaware law. And third, plaintiff's fraud claim is belied by the express language of the stock purchase agreement, including plaintiff's acknowledgement that a merger might occur at any time, in the contract's 4-page contingent consideration clause, which addresses mergers at prices far exceeding what metadata actually paid for SHYFT. Now, I'd like to start with the waiver issue, Your Honors, because it really, I think, resolves the breach of fiduciary duty claim here, as well as the fraud claim. We had argued in our motion to dismiss below, in part, that plaintiff had failed to adequately allege negotiations for purposes of the 9B standard. In response to that, plaintiff specifically and repeatedly argued that this was not a case about negotiations, but only a case about expressions of interest. They called the idea that their case was about negotiations a straw man. They emphasized, and I'm going to quote here, defendants do not cite a single paragraph of the complaint that actually frames ATHRU's fraud claims as arising from undisclosed negotiations, because that is not how ATHRU pleaded its claims. They identified one paragraph in the complaint that had the word negotiations in it, and then said the word negotiations appears just once in the entire complaint, and followed that up by saying, and again, I'm going to quote, the court should test the sufficiency of ATHRU's pleaded claims, not the unpleaded claims that defendants would prefer to challenge. So below, they framed this case entirely as a case about mere expressions of interest, not negotiations. And I think now, realizing that mere expressions of interest fail as a matter of law, they've tried an appeal to make this case all about undisclosed negotiations. If you look at their opening brief, they repeatedly suggest that they alleged there was some agreement in principle, that the parties had actually been talking about price, that it was everybody's intent in the summer of 2017 to move forward with a merger that was, quote, impending. None of that is in their complaint. The complaint was about expressions of interest. And so I'd like to address next what Delaware law actually is about expressions of interest, because Delaware has not abandoned the notion that you need to actually allege and prove that merger talks are pretty far along before there's any cause of action for breach of fiduciary duty. If you look at post-Alessi cases like In Re 9 Systems, Wayport, David Simonetti, all of which are quoted in are discussed in our brief, what you'll see is that you essentially have to have either an agreement to those material terms, or at a minimum, a firm offer made by the purchaser. It is not enough, and these cases repeatedly say, you know, if the purchaser is still kicking the tires, if they ask for a couple more weeks for due diligence, that's not good enough. If there's a counteroffer, which is outstanding, and the purchaser has not expressed interest in the counteroffer, that's not good enough. In every case where there has actually been a cause of action for non-disclosure accepted by the courts, what you see is that there's only a couple of weeks left in the negotiations. There's a term sheet. The parties have had multiple meetings at the most senior levels where specific prices have been discussed. And only right after the shareholder transaction usually within days, within 7 days, within 2 weeks, the other deal gets closed, the one that should have been disclosed to the shareholders. That is not at all this case. What they pled in their complaint is that there was not even an NDA signed between SHYFT and Metadata until 3 months after the stock purchase agreement was signed between the plaintiff and the defendants. 3 months is an eternity. Even once the NDA was signed, it was 4 more months before the SHYFT Metadata deal closed. Under those facts, you cannot, there can be no inference that the parties were extraordinarily close to a merger, that they'd effectively reached an agreement in principle, where it was 7 months before a deal closed and they didn't even have an NDA to talk about the most sensitive information for 3 more months. My friend on the other side repeatedly suggested 2 things here about the status, the stage of this case at which it was dismissed. First, that they were denied discovery. They should have a chance to replead, or at least to get discovery. And second, that they had some contractual right to the documents they're looking for, and that we violated that contractual right. Well, as to the first, if in response to our motion to dismiss, if plaintiffs thought they had more facts they could plead, they could have asked below for a leave to replead. They could have sought reconsideration from Judge Salinger. They did neither of those things. It is only to this court that they've asked for the first time for leave to replead. And even when they do so, there's no suggestion in their brief, you heard no suggestion today, about what additional facts they may put into an amended complaint that would allow them to survive a motion to dismiss. That's because there are none. And second, and you can look at cases like Johnston versus Box, it's an SJC case that we discuss in our brief. I mean, it is not enough just at the appeal stage to do some hand waving and suggest you might be able to plead more if given the opportunity. You have to actually make a showing about what you would plead and explain why that would allow you to survive a motion to dismiss. As to the contractual rights, there's no broad contractual obligation in the stock purchase agreement for defendants to produce all of the corporate books and records to a former shareholder. And ATHRU was a former shareholder by this point. Under section 1.4G of the stock purchase agreement, there is a very limited contractual right to documents. What it says is, quote, plaintiff can obtain certain books and records in each case solely in connection with the determination of amounts payable to the seller under this section 1.4 or any dispute related thereto. So if the parties have a dispute about how the contingent consideration clause works and what the amount of contingent consideration should have been, they can get documents that would allow an arbitrator to decide, okay, what should the contingent consideration amount have been? There is no contractual duty for us to produce documents about the course of negotiations between Metadata and SHYFT, going back to the summer of 2017. And 2 more points about this contractual provision. First, we have produced, and the documents are in the record, if you look at the exchange of correspondence between the parties, we produced a substantial volume of documents to the plaintiff concerning the calculation of the contingent consideration. In fact, that's led to certain of the disputes about the calculation of contingent consideration being mooted, and I believe some small additional amount being paid. Second, whether this goes to counts 1 through 3, which were dismissed because they should have gone to arbitration. If they think we have not produced to them all the documents that they're allowed to get under section 1.4G, then they should take that to an arbitrator. It should not go to this court. And Judge Salinger was.
Maybe I misunderstood Ms. Milkey, but I thought she was indicating that obligation preceded the signing of the stock purchase agreement, not the contingent purchase, purchase price, but the prior to the signing of the stock purchase agreement, there was an obligation to disclose that information, whether it was contractually or fiduciarily, if that's the proper word. That the obligation was there that she's talking about. Maybe I misunderstood her argument. And
yeah, so they have, I guess, three arguments, Your Honor. First is that that the meetings, the expressions of interest should have been disclosed as a matter of Delaware fiduciary duty law. Their second argument is that certain information, the expressions of interest, should have been disclosed because they say the absence of expressions of interest was a fact basic to the transaction. And we addressed that in the brief, and I'm happy to address that today too. And then the contractual argument they make is that they point to section 1.4G in the stock purchase agreement and say that gave them a contractual right to books and records. But that right only would have been exercisable after they had stopped being a shareholder. It would be a matter of contract as a former shareholder party to this. There's no allegation, for example, that they made that before the stock purchase agreement was signed, they made a books and records request that they would have the ability to make under Delaware law to get whatever books and records they might be entitled to as a shareholder. With respect to the issue of basic to the transaction, I'd like to focus on a couple of points here. The first is that they were originally prepared to enter this deal with a third party. So they agreed to all of these economic terms with somebody who would have had no access to this information whatsoever. And if we had not invoked our right of first refusal, they would have presumably gone ahead and entered the deal with that third party. I think that just puts a fine point on the fact that the information we had available to us was not information that they needed to have before deciding whether to sell their stock to somebody, whether us or that third party, on these particular economic terms. And so, Justice Milkey, that goes to the point you were making. When you look at the language in the contract, which says we have all the information we need, I mean, yes, there's case law saying that you can't waive a fraud. But in terms of what is basic to the transaction, what did we actually have an obligation to disclose? That very much informs what's basic to the transaction because it confirms that they did not need any of this information before deciding to move forward. The complaint itself alleges they'd been trying to get rid of their stock for nearly 2 years before the stock purchase agreement was signed. They viewed SHYFT as a company that was bleeding cash and they wanted out. And so they agreed to sell their stock to a third party. And then they sold it to us again, only because of the right of first refusal agreement. You had a question, Justice Desmond, about what the complaint alleges concerning that August meeting between SHYFT and Metadata. It does not allege that we engaged in any kind of acts of affirmative concealment. All it alleges is that it was not disclosed. So again, there's really not much going on here. You have at best expressions of interest, according to the complaint, according to what they argued to Judge Salinger. You have several months later a non-disclosure agreement, and then you eventually have a deal 7 months later. This is just not the kind of case where either Delaware law or Massachusetts law allows a plaintiff to go back, undo the deal that they agreed to on the theory that they lacked information and would have acted differently if they had known more. With respect to the breach of contract claim and the arbitration clause, unless the court has any questions, I'll probably rest on my brief with respect to those. And the only other point I would like to raise here is that the individual defendants do have their own defenses, even beyond those that are available to the defendants as a group. So Mr. Hirschfeld, there's no allegation in the complaint that he was even aware of whatever expressions of interest were being made. And so Judge Salinger correctly found he couldn't breach a fiduciary duty if he wasn't even aware of the information that should have been disclosed. And with respect to whether Mr. King was a facilitator, if you look at the facilitator cases, usually they involve somebody setting up the deal, luring the plaintiff into the deal. Again, that's not what happened here. Plaintiff was prepared to move forward, selling the stock to a third party, regardless of whether these particular defendants invoked the right of first refusal and purchased it themselves. And with respect to Mr. King in particular, he wasn't even a purchaser. All he's really alleged in the complaint to have done, and we walk through this in our brief, is have acted as SHYFT's CEO and done the kinds of things you would expect the CEO of a company to do if there was a transaction between major shareholders. He sort of had oversight. He issued whatever approvals were necessary for the stock sale to go through. That's all. And if you look at cases, again, like Wayport, Melcher, and 9 Systems, all of which are discussed in the briefs, that does not amount to facilitation. So if there are no further questions, Your Honors,
Just one from me. About 2 minutes ago, you mentioned either under Massachusetts or Delaware law. I assume, tell me if I'm wrong, that you actually agree with Attorney Lukey that the main substantive question here in terms of what is an actionable non-disclosure case is a question that needs to be resolved under chancellery law in Delaware.
Under Delaware law for the fiduciary duty claim, Your Honor, but I think Massachusetts law would govern the fraud claim, the failure to disclose facts that are supposedly basic. I mean, that kind of goes back to the Delaware question because it would only be basic if there was some duty to disclose it. But so at the end of the day, you're right, but I think conceptually both sets of law apply to different claims.
This may be, maybe I shouldn't ask this question, but it's in my mind. If the plaintiff had pled in the complaint along the lines they argue in their current brief, in other words, that the negotiations had proceeded, that it's inferential, that they were beyond an expression of interest, is that what would have been sufficient theoretically under this type of pleading or complaint? In other words, they would have had to plead, even though they didn't have that. In other words, the quandary is they don't have that information, but they've seemed to piece it together, at least in this brief, that says they had to be beyond a certain stage. It's inferential. Are you suggesting, or can you tell me whether or not you believe that might have been sufficient if it was pled in that manner initially, or as a result of an amendment?
So, Your Honor, it would depend upon what the non-conclusory factual allegations were. They would have to have non-conclusory factual allegations that make this case feel more like a lessee and less like all of the other cases that we cite. And when you look at,
go ahead.
Okay, and Your Honor, when you look at the actual facts rather than conclusions that are pled in the complaint, the only real facts that are pled are, again, that the NDA was not, that there wasn't even an NDA until several months later, and that the deal didn't close until 7 months later. And so against those two very notable facts, the conclusory allegations that they've tried to weave into their brief would not be sufficient to give any reasonable inference that this was an lessee type situation.
Okay, I appreciate you addressing that.
Thank you, Your Honor.
Unless my colleagues have any further questions, and seeing none.
You're live and recording.
Thank you very much. We are here back on the record for our fifth and final case of the morning. The case is Sherwin versus Department of Children and Families, 2021 P5. I want to remind the parties that we have read the brief, so we are familiar with both the facts and the arguments, and therefore we urge you, to the extent possible, to cut to the chase. And with that, I will turn the floor over to Attorney Wells.
Thank you, Your Honor. Initially, I think the record, as my brief lays out, establishes a claim that it does establish a claim for each violations of FIPA. And there's a lot of, I'm going to go through the points that my brother brings up. He brings up a notice issue, and there was proper notice. If you look over, first of all, the interrogatory response that we served in November, there was significant discussion in detail of our claims, and before that, the facts that we rely upon were asserted. And
but counsel, let's back up a little bit.
Oh, sure.
There were pending motions for summary judgment, and those were not opposed. And by that I mean there was no response to the statement of material facts served under 9A. There was no opposition either submitted pursuant to 9A or otherwise, nor was there a request for, the filing of a Rule 56F certificate saying why discovery had to go forward before a summary judgment motion was warranted. As I'm sure you're aware, people file for summary judgment all the time before the conclusion of discovery. Sometimes it's appropriate, sometimes it's not. It appears uncontested that your client did not oppose any of this. And the one fact that you appear to have in your favor is that during a hearing on a discovery issue, I believe it was, in fact, Mr. Hartnett was starting to offer some more time, and the judge cut him off and said, we're not going to hear summary judgment until discovery is over. So at the point after discovery then in fact closed, you had an argument that you could have gone back to Superior Court and made, saying, Your Honor, I was promised that we'd have more time. At least I interpreted it as a promise. And, you know, you shouldn't just rule on the motion for summary judgment, you know, be it through a 60B motion or something else, but to go back, throw yourself on your sword and say, we deserve more time. That was not done. And instead you filed the appeal. And what's before us now, you tell me if I'm wrong, but you haven't even responded to the arguments in the summary judgment motion that was allowed in terms of, you know, had we responded, these are the additional facts we would have tried to get in front of the court, or here's why the legal arguments based on uncontested facts are wrong. Instead, what we're seeing is an argument that, well, ignore all that. We have this FIPA claim, which was never pled, and you should send this back because we may have a valid FIPA claim.
Your Honor,
I dumped a lot on you. Let me turn
sure.
back.
Initially, I filed a Rule 33A notice, and judgment should have entered then. I filed it in response to the summary judgment motion because there had been no interrogatory responses. There had been no depositions. Now, how can I respond to a summary judgment motion which requires admissible evidence if I'm not allowed access to evidence?
But
and that's what I thought.
There are tracking orders in place that clearly I think you were aware of throughout the course of the litigation because they were extended at different times. You never extend, in other words, you know, the Commonwealth filed their motion for summary judgment to comply with the tracking orders. You received it, you ignored it, you didn't move to extend the tracking orders for further discovery. The doing nothing at that point, relying on a Rule 33A or whatever, which was ultimately denied out of hand, and not to go back and say, well, wait a minute, we thought we had more time. I mean, I think that's what Judge Milkey's saying. There was a structure in place that you were aware of, and you did nothing at that point other than to rely on an alternative motion.
I asked for alternative relief in there. This was during the COVID pandemic. Everything was closed. I understood that the deadlines weren't for a while. I did raise this issue with the courts. We were in conversation with the clerk's clerk setting a schedule. This was during the height of the pandemic. We're with the clerk discussing a schedule, and at the hearing that schedule came up again. So we discussed it, but I did ask for alternative that the summary judgment be denied an opportunity for me to have discovery in the Rule 33A application.
When Attorney Hartnett approached and said, listen, we'll join you in a motion to enlarge so that you can get an opposition in, why didn't you take him up on that? It seemed like you ignored that as well. And as to the 33A, I thought the court found that you had gotten some responses. You just didn't care for the responses, but not that 33 answers. You didn't get any responses whatsoever.
Thank you. So I did take Attorney Hartnett on it. We were in discussions on it. We were talking about it and we're coordinating it. I don't understand where it comes from that he says that I didn't take him up on the offer.
Did you file a motion to enlarge?
Yes.
At what point?
I'll forward the emails. There were conversations, multiple conversations.
No. Did you file a motion to enlarge the time for the opposition? Not that it was an email. Did you file a motion to enlarge your time for your opposition?
I did not file one. I presented an oral request at the hearing. I mean, I thought we were discussing, but no, Your Honor, I did not file one directly. Again, it was during pandemic. There was a lot of confusion through dates, and we're talking with the clerk trying to set a schedule. And I think filing a motion to enlarge the time at that point would have been unnecessary because we were having conversations about it.
There is a suggestion in your brief that you think you were entitled to be able to file summary judgment affidavits up to a day before the hearing. Where does that come from now that Rule 9A has been in place for a very long time at this point? This is not the go-go days of the 1980s when I was in practice.
Rule 56 entitles, says that up to the day before the hearing, the person, the party may submit opposing affidavits to a motion for summary judgment.
But Rule 9A layers on top of that a very specific procedure for the orderly development of the summary judgment record that requires, among other things, a direct active response to the statement of material fact. And if you don't do that, the facts are deemed admitted under the terms of the rule.
I understood that the record still had to support the facts. I understood that they were that they may be deemed admitted if they were supported by the evidence. I believe that the judge still has the duty to review the record to make sure that the facts are in fact stand what they're going for. And here, the rule, I definitely opposed it. The court knew. The court said during the hearing, he said, we're not discussing summary judgment right now when we talked about the issues, and we were resolving it orderly. And he said, well, hear that. And again, it was during the confusion of the pandemic. What happened here is on the 17th, when the order for the first pandemic order of COVID issued, the court granted that order without, I thought on the 17th, but apparently it was after the court was filed on the 23rd, and they granted a motion to enlarge, which I really limited the deadlines. That shortened the deadlines. And with all the confusion and the fact that we were in conversation with the clerks, to me, I think it's reasonable to rely on the court saying, okay, you have this time, and we're gonna address this. And even if it's not, the record still supports the question of material fact.
Well, why didn't you go back to the Superior Court and say, Your Honor, I can understand why the court granted this what appeared to be an unopposed motion for summary judgment, but here's the problem. There's COVID. There's the promise that I interpreted the judge had made at the discovery hearing. And at a minimum, give me an opportunity to amend the complaint to plead something that nowhere appears in the current complaint. And at that point, that is a discretionary call of the judge you're in front of, whether or not to allow that. You're now on appeal to us on the granting of an unopposed motion for summary judgment where your response goes to an issue that was never part of the complaint.
Your Honor, it was part of the complaint. The complaint alleged that they were disseminated, they were given to employers, potential employers, for private information. Factually, the complaint was pled. That's what's required. And that is, in the case law says, for a FIPA claim count, you don't do a FIPA count. You do a torts claim under Chapter 258, and that's what was done.
Is FIPA anywhere cited in the complaint?
No, it doesn't need to be, because the facts are asserted, and there's no count for FIPA now. You have to assert it under Chapter 258. And if it's a notice issue in November, FIPA was very detailed in the response there, relying on the same facts, that the information that was provided by the agencies to our potential employees was false, and it caused them to lose a job, and that those violated HIPAA. Now, it's a statutory duty. This was asserted under the Torts Claim Act with the statutory duty. The facts were asserted, and the statute, there's no requirement that you have to cite the case law and the statutes in your complaint. I think most of the case law says the opposite. Assert facts, allegations, and the factual allegations were made, and they were amplified in discovery in response to in November. And here's the thing with the interrogatories. We asked for what defenses they had. That was never provided until summary judgment. And it wasn't an idea of, I didn't like the responses. The interrogatory responses were useless. They said, here, rely on these documents. They hadn't produced documents at the point. How can I rely on documents that haven't been produced? How is a person signing that under perjury? They didn't.
Useless or not, there's still responses, which is different from 33A, which is you receive no responses.
Your Honor, I think it's a reasonable interpretation, and a Superior Court decision, which I cite, has made that, which was recently affirmed, that if the response of, serve a piece of paper in response to interrogatories that say objections and responses and nothing more, or just, puts some pictures on there and tries to do that, that's such an inadequate response that they're non-responsive, they're not responses.
Did you file a motion to compel?
I didn't have the time, I didn't have the bandwidth. And the Rule 33A, I think, was a significant, the responses were useless. I mean, they served something under pains and penalty of perjury that cited documents that had not been served at the time of that. I have no clue what documents those are. They didn't respond to the others. They said they would serve them. And then they waited, and then this surprised me. With all of this information came at summary judgment. Now, I asked for this information. I need interrogatories, Your Honor, because that's admissible evidence. I needed depositions because that's admissible evidence. I didn't get any of that. And that's the issue. There was no admissible evidence I had available to me that I had asked for.
Okay, counsel, just big picture, what are the damages you are seeking in the FIPA claims? What's the most you can hope to gain if you were to go back and be able to prosecute these claims?
The most is $200,000 under the Chapter 258 limits the claims.
But the question wasn't as a matter of law, what's the cap? But on the facts established on the summary judgment record, both agencies fixed the problem when your client's attorney, I don't know if it was you or predecessor counsel, brought it to the agency's attention that what you call flags were still on the file. So, and then the one entity, a future employer who inquired of DCF, DCF immediately fixed the problem and your client got the job. So where are the damages here, as a matter of fact?
Sure. So the DCF had sent it to other employers before that. This is when this was the information I moved to compel for of who, with the identity of these employers, or who were they sent to. And one of them was Lawrence. And in that fall, this is detailed in the interrogatory response, Dr. Sherwin had been essentially offered the job. She was going to take a urine test. Apparently, they received notice from DCF that she was on the list well, she had been found responsible for abusing 4 special needs children. At that point, the job just was gone. And there's also, in addition to her losing that job, there's the emotional distress that a career teacher who has, resolved these basically false allegations in the first instance, has a superior court judge say this was BS. This was a career teacher who has a commendable record. To go through all of that, and then to find out, oh, she's still being the 2 government agencies are still telling everyone that she had abused 4 special needs children. She had emotional distress from it. That's detailed in the interrogatories.
And are all the interrogatory responses in the record before us?
They're in the summary judgment record. Yes, Your Honor.
Okay.
And
go ahead.
where can I find evidence that they sent your client's information to the Lawrence Public School? Where's that?
Your Honor, so that is, it's in the interrogatory, and then there's also the list of that you have to follow the rabbit hole, but there's 4 instances where they sent the records, 1 in September. The first 2 that they refused to.
If you can just point to me in the record where I can find the evidence that they sent them to Lawrence Public Schools.
Yes, Your Honor, it would be, it'll take me a couple minutes to give that. I'd have to find it, but the records are the 4 times that they sent the DCF had distributed the records to the school, or distributed the records. 2 of them we had to move to compel, and we don't have those, but it's the one in September is the one combined with Dr. Sherwin's testimony creates an issue of fact whether those were sent to Lawrence Public Schools.
Okay, one very specific question. Your brief keeps referring to your client as Dr. Sherwin. Where does the doctor come from where the record seems to say she has a master's?
She received her doctorate in 2000, I believe 15 or 16.
Okay.
And
unless my colleagues have any questions, we will have to move on.
Can I just make one point?
You have 20 seconds.
Okay. In regard to who the information was sent to, that also wasn't tracked by either of the parties, and that would be a violation of FIPPA 2. However, they did send it to Lawrence Public Schools and 3 other schools, and that was a violation in the damages, even if both that and emotional distress creates damages issues. Thank you, Your Honor. I appreciate it.
Thank you very much. We'll hear from Attorney Hartnett.
Thank you, Your Honors. The Norfolk Superior Court did not abuse its discretion when it allowed summary judgment motions that remained unopposed for nearly 2 months. The court waited 7 weeks before allowing the motions as unopposed. During those 7 weeks, it did not receive an opposition, a motion for an extension of time, a Rule 56 affidavit, or any other response whatsoever.
No, counsel, that I hear you. It's also true that at the hearing on the discovery motion, you were starting, unless you tell me I'm misinterpreting your remarks, you were starting to offer more time to Mr. Wells, or predecessor counsel, and the judge cut you off and said, wait, we're not going to hear summary judgment until he's had an opportunity to get discovery. Why wasn't it reasonable, at least until the time that discovery closed, for Mr. Wells to rely on that, notwithstanding what the rules say in terms of deadlines?
Your Honor, I think your interpretation is mostly accurate as to what was said during the hearing. And I think what happened, if you read the whole context of what happened here, was I was just trying to bring up the fact that I had filed these motions as unopposed. And I wanted to sort of clarify as to when things were due, but the court just cut me off. And I think what the court was trying to say there, and I think it's clear from the record, that what it was trying to say was that the summary judgment's not before us today. So I'm not going to hear that until I deal with all the discovery motions, the 7 discovery motions that I'm dealing with today. So I don't even want to talk about it. And I think there's other points in the transcript where it mentions that too. And as to whether or not it was reasonable for plaintiff to assume, I don't think it was reasonable for him to assume that he had more time. Her opposition was already overdue. There was no, and as you noted, there was no extension. There was a written order written the next day. And that written order doesn't mention summary judgment or an extension or anything like that at all. And she never filed a Rule 56 affidavit, which would be the mechanism by which you would get additional time to respond to a summary judgment motion.
In your brief, you say that, or at least you suggest that the plaintiff should have gone back to Superior Court through Rule 60 or whatever and said, Your Honor, here's what happened. Here's what you or your colleagues said at the recent discovery hearing. And oh, by the way, we're in the middle of COVID. We need more time. Give us another chance. A suggestion that, by the way, I, for one, agree with, that that's what should have been done. But isn't the flip side of that also true? That had counsel filed such a motion, there's at least a decent chance it would have been allowed?
I mean, it certainly would have been up to the court's discretion to determine that. And it is possible that given these circumstances, it would have allowed it. However, the court would have also considered the merits, would have needed to consider the merits of whether or not this is really something that needs to be revived. And for all the reasons I've noted in my brief, there really was no merits to these underlying claims. So I do think there's actually a very good chance that despite, even if the court felt that it was reasonable for Attorney Wells to make this mistake, that it would have said it doesn't matter because there's really no merit to these claims.
Well, let me press you then on the FIPA stuff, because you've heard your colleague at the bar say that, under notice pleading, he has to plead the facts, and the fact that he never mentioned FIPA is immaterial in the end, and that had he filed such a 60B and the judge wanted to get into the merits, he would have said, FIPA, and to the extent we need to replead, we'll replead, but it's pled sufficiently, and the Commonwealth hasn't said why the FIPA claim failed.
Sure. I mean, first off, the complaint does not, the complaint actually expressly says that this is a negligence claim. It says that she received her damages as a result of the negligence of both agencies. So for plaintiff to go back and say, no, that was really something else, that's not what the complaint says. So in terms of giving us notice, we were being told that this was a negligence claim. Additionally, since it's a tort claim, there would also be a requirement to put us on fair notice that you are claiming these type of things in a presentment letter, which the presentment letter doesn't say that as well. Additionally, I would note that a lot of the information that plaintiff relies upon for her FIPA claims in her appeal were never before the court and were never in the complaint. They were actually well beyond the facts alleged in the complaint. He's not alleging just alleged violations of, he's alleging allegations about general maintenance of the agency's records, not just that because DCF didn't update its records for a year, that was a FIPA violation. He's doing much more. So I think a lot of that is not in the complaint as well. Your Honor, so just to go back, as your Honor's noted, there is no right to a hearing under Rule 56 or 9A, as as Attorney Wells, or sorry, as plaintiff suggests. And even if such a right did exist, Superior Court rules make very clear that if you do not request a hearing and there was no request, that it's waived. And then, Your Honors, even if the court could also affirm this on several alternative grounds. First, for DESE, the DESE claims are required to be dismissed and should have been dismissed because they were barred by Section 10E of the Tort Claims Act. 10E bars any claims that is based upon a licensing decision. As this court has ruled in the past in Smith versus RMV, 10E is not limited to just direct challenges to a licensing decision, but includes anything that's rooted in a licensing decision. And here, DESE opened an investigation into whether or not to suspend or revoke plaintiff's license. Sherwin's claim against DESE, even if it were factually true that they somehow disclosed information after her DCF findings were overturned, what she's saying is that the agency should have then stopped its investigation after those findings were overturned, because it can't say that it was outdated or inaccurate, and there's no basis, nor has she ever claimed that it would be unlawful for the agency to disclose a public information about the fact that she's under investigation. So really what is going on here is a claim that the claim is that she's making is that when those DCF findings were overturned, they should have stopped their investigation. That's a direct challenge to an investigation. And the challenge to it in the licensing investigation has to be covered under 10E, because 10E, if it's not, then any person who wants to sue, wants to complain about the decision, could just circumvent the entire rule by complaining and saying that the underlying investigation was negligent. And 10E would never have any.
But counsel, 10E does not apply to DCF in this context, correct?
What do you mean, Your Honor?
The argument you just made is specific to the Department of.
Oh, yes, sorry. Yes, Your Honor. That's specific to just DESE. As to the other two agencies, there's alternative grounds. The record fully supports, and it was never challenged, and it was before the court, and there was no opposition. And even if it was, we're talking about business records. This is a claim that business records weren't updated. Plaintiff says he asked for the business records. We turned over the business records, and business records just simply don't say what plaintiff thinks they said. She speculates that other things happened, but that's simply not what the records show. And this isn't just business records. We've actually gone as far as to actually pull the metadata to confirm those business records. As for DESE, the idea is that her license was flagged. It has been continuously flagged, but the records clearly show that her license was marked under review on October 10th, 2010, which is right after DCF supported the allegations against her. And then on June 25th, 2012, a year and a half before DCS findings were even overturned, on that date, the flag was removed per an agreement with her attorney, which is documented in a letter from her attorney the next day, in which they say, we understand you're going to keep her under investigation, but can you remove the flag so that there's no public indication that she's under investigation? And that's what DESE did. And that we provided the metadata that even confirms that those entries occurred on those dates, exactly as there is. So there's really no merit to that claim. And same thing with this misconduct list, until the plaintiff had never explained what she even meant by a misconduct list, but presumably she meant a list that she would have been on, a list of people who were under investigation. There is no such list. The closest thing to a misconduct list is the DESE periodically publishes a list of people who were sanctioned, but she was never sanctioned. So that's not at all what she's talking about. And in fact, if you go back to the presentment letter, she didn't refer to it as a misconduct list, but she actually referred to it as a misconduct website, which made us think that she was really just referring to the website itself.
Let me interrupt you. Your suggestion is that we review under abuse of discretion only. To what extent does that require us to look at the summary judgment record? I mean, the judge below seems to have just entered an allowance as there was no opposition of your summary judgment. Doesn't reflect what it's based on the merits or that there was no opposition allowed. Suggesting whether that we review that action for abuse of discretion only.
Well, Your Honor, I think the standard here is abuse of discretion because that's the standard on which plaintiff is arguing. He's arguing that it was procedurally improper to issue this order. His substantive arguments are the ones related to FIPPA and other things that were never pled. So they're not really, he's not really arguing any of the substance of the underlying summary judgment.
He does argue there is a de novo review.
I believe he actually says it should be, he says there should be de novo review for the FIPPA and the 119 claims, but he does not say that in general. He says there should be, he says for the ultimate decision, the judgment, it should be abuse of discretion. And it should be abuse of discretion because this was ultimately a procedural determination based on failure to comply with Rule 9A. Now, the court did review the document. It does actually note that in its judgment that it reviewed, it says that the document's been reviewed. So it didn't, in fact, review them, but then ultimately decided that given that lack of an opposition and the failure to comply with 9A, it was well within its rights to dismiss the case.
Assuming, this is complete hypothetical, but assuming that the FIPPA claim, to the extent it's based on this allegation about Lawrence finding out the flag, to use the plaintiff's term, lost her a job, on the merits of a FIPPA claim based on that, are you arguing that that would fail as a matter of law, or merely that that claim is not before us?
Well, both, Your Honor. I am claiming it would fail as a matter of law as well, because the record actually indicates, so as to Lawrence, there's nothing in the records that indicate that Lawrence Public Schools ever received anything from DCF. The document that plaintiff cites, it actually specifically says this is information that was given to EEC. The process, schools don't just get information from DCF. That's not how the process works. In fact, schools, like public schools like Lawrence, are under no obligation, and there's no reason to think that they would ever ask for DCF information, nor could they ask for that information directly from DCF. The way it works is for licensees of the Department of Elementary and Early and under EEC, those agencies, which may include private schools that have residential programs for developmentally disabled children, like the League School where she applied. So EEC schools are required to ask DCF or have access to DCF records so they can run a DCF background check. And that's part of their regulations and their statutes, and they're required to do that. Lawrence Public Schools is not required to do that. And that actually makes sense if you think about it, because all the teachers and the educators at Lawrence Public Schools are licensed by DESE. And DESE itself automatically receives any supported allegations, and then it runs its own determination as to whether or not a license should be suspended or revoked. So if DESE has that information and is not determined that it rises to the level of suspending them, then the school isn't privy to that information. So there is no support for this idea that it's Lawrence Public Schools. It's pure speculation. As for the FIPPA claims, the issue with the disclosure to EEC, to the League School via EEC,
Counsel, we know the argument you make on that in your brief, which is very clear. So I appreciate you're going to repeat it here, but we know what the argument is. Do either of my colleagues have any follow-up questions? Counsel, if you want 20 seconds to sum up, the floor is yours. I guess you either didn't hear the offer or.
Yes, I didn't know if you're
No,
talking.
no,
to me.
no, not.
Oh,
there's no-
okay.
There's no reply. I was asking.
That's what
Attorney. Yeah. Thank you both very much. The case is submitted, and that brings the hearing today to a close. Our thanks to both the clerk's office and the IT team for allowing this Zoom hearing to happen. And with that, the case